Khan. I am the chair of the Public Safety Subcommittee of the Advisory Committee, and I welcome you. So just a little bit about process. So for the Advisory Committee, which is the Finance Committee of the town, which makes recommendations to town meeting, it's the subcommittees that hold the public hearings. We will take public comment. We will discuss the issues that we've heard. We may or may not choose to make a recommendation to the full advisory committee, but we will write up a report. And then next Monday at approximately 8:30, the full advisory, which represents the full advisory committee, Tuesday, the 29th at around 8:30. The full advisory committee will discuss this issue. The subcommittee will give its report. There will be more discussion, but there will not be public comment at that point. This is where public comment happens. And so I very much appreciate you coming out tonight. It's the recommendation of the full advisory that will be the recommendation to town meeting. So just to give you sort of the sense of where you sort of play a role tonight in this issue. So tonight we are doing, it's a public hearing on a warrant article that was filed by Amy Hummel, which would ban face recognition software in Brookline. It would be a new bylaw in the town. So this is not a resolution. This would actually become law in Brookline. And so I'd first like to introduce us as a committee, and then I'll ask Amy to present the article and why she submitted it for this warrant. So again, I'm Janice Khan. I'm a town meeting member from Precinct 15 and on the advisory committee.
And I'm Lisa Jonas, and
Mike.
I'm Elisa Jonas, and I'm a town meeting member from Precinct 16, and I'm on the advisory committee.
And I'm Susan Branoff. I'm a town meeting member from Precinct 7, and I too am on the advisory committee.
We all are on the advisory committee.
David Mark Goldstein, town meeting member from Precinct 8.
Thank you, Dean. All right, Amy, would you like to speak first?
It's a very short mic. I don't know if you can hear me or not. Is that fine?
Yes.
Okay. So thank you for having me this evening for the hearing. My name is Amy Hummel. I'm a town meeting member from Precinct 12. Thanks everyone for coming out to speak. I'm the warrant article petitioner. This bylaw, as you said, seeks to ban the town's use of face recognition technology. I'm going to read a little bit about what I have and then talk a little bit more. So specifically, it seeks to prohibit the use of the technology by the town throughout the town, including in and around our public schools, libraries, public buildings, and in and along our public ways. It also acts to support Senator Cream's bill to place a statewide moratorium on the technology and provides Brookline with a more immediate protections against the use of this software, which presents serious First and Fourth Amendment concerns, among others. Why a ban? As if saying First and Fourth Amendment concerns aren't enough. This technology is utterly dystopian and deeply flawed. There isn't a single federal or state law that protects us from it. So let's talk about those flaws a little bit and what this technology could do to us if we let it, because the businesses who sell it for profit, the businesses who profit from the absence of law, are widely and actively lobbying our government, state and federal, and marketing face recognition as a cure-all. But it's anything but. This technology misclassifies minorities, women, and children at a shockingly high rate. White men are not immune either. In some cases, it is 30 to 70% accurate at best. Imagine the trauma of being a false positive or being detained or put on a watch list because AI thinks somebody you're not, or even if you're erroneously targeted, imagine that trauma and stigma of being a false positive. It's likely to last for a long time. The technology also risks shifting our norm from innocent until proven guilty to not guilty of a crime yet, but you're being watched. That mindset amplifies fears and suspicion in society. It threatens to change the way we think about each other, the way we treat each other, and it impacts our behavior in public, curtailing creativity, and it overall just threatens our collective psyche. There are First and Fourth Amendment concerns as well, because in the absence of law, there are substantial due process concerns. It certainly stands to chill free speech, dissuading people from attending political rallies because they might be identified or put on a watch list, or someone who looks like you could be put on a watch list and identified. Or maybe you look like someone who went to a rally that you didn't go to. Or simply, it could impact how we feel about going to maybe a health clinic, a specific health clinic, or an AA meeting, or a therapist, and participating in any number of legal private acts that the government really has no business recording, aggregating, storing, sharing. And it can be done through time too, right? It's not just current here forward, or all of it can be taken and manipulated in multiple ways. So the technology really does strike at the heart of our most basic rights. It turns our face, who we are, into a trackable ID badge. You can delete cookies, you can change your phone, you can opt out of some things, but you can't change what you look like easily. Free people don't have to wear an ID badge when they walk out the front door or produce an ID wherever they go. They don't have to stand in a virtual perpetual lineup. And yet, in the absence of law, most of us are already stored in that lineup. The FBI is known to have scooped up pictures taken for a civic purpose, right, from the RMV, and 1 in every 2 adults appear in some of these databases. There are no laws or rules to stop them, no process whatsoever. Obviously, this law doesn't impact the feds, but you see where the path leads in the absence of law. So, just because Silicon Valley can make it and businesses can push it and profit from it doesn't mean we have to let them run roughshod over our liberties and our human interactions. There is a growing technology backlash in some ways, so now is a good time to join other progressive communities, both next door and across the country, to nip the use of this technology in the bud. We shouldn't be complicit in tacitly normalizing it by not acting. And I'll speak about that in a minute, but I will finish these comments. And, you know, even if and when it's perfected, even when this isn't flawed software anymore, that's almost more terrifying, because the government use of the technology could be so pernicious in undermining our civil liberties that we really need to just stop, ban it now, and then if there are little carve-outs we need to do, we can discuss that, but a ban, immediate and clear for everyone. You know, this isn't a technology that we've had or we've used, we've come to rely on, thank goodness, and the longer we let it go unfeathered, the more likely it is that people will just sort of become anesthetized, numb to it, or be cowed into agreeing to use it. So free societies don't do this to each other. I hope this is not who we want to become. We don't do it now, and let's not start. And I want to say a few things. I don't know if you have me on a timer or not, what I've got here.
You have another couple of minutes.
Thank you. So I want to say something about process too, because you know, there have been some questions about this particular warrant article and why now. Hopefully I've addressed that, in that there's a bill in the Senate that's relevant to us. The technology is being more and more widely reviewed, understood. We know there are no laws in place, and so it seems like just the absolute time to act. And this is our process in Brookline. It's filing of a warrant article, going through the multiple meetings, having the discussions, as difficult as some of them may be, seeing where there's room to clear things up a little bit, which you'll see. And I don't know, for people in the audience who may have looked at the bylaw as I originally filed it, it's now I've made some changes, some clarifications. So, you know, that's all part of the process. It doesn't mean we all come to agreement in the end, but this is it, and it will continue to happen up until town meeting, when town meeting, I believe, has the right to vote on this ban and on a complete ban, which I am putting forward. And then I can answer, I'm happy to answer any questions about this. I mean, I could talk all night about the civil liberties piece. I'm hoping many people in the audience will make points around that. But I will say, I just, yesterday at the State House, hearing some of the testimony was really inspiring, particularly from the League of Women Voters, who is, notoriously nonpartisan, right? And just, they're stepping in and making a statement. This is so concerning to them around the potential for abuse. And again, we're not saying anyone in town specifically is doing anything so terrible, but by not acting, we are complicit then in the other bad behaviors. By making a statement, it becomes this grassroots movement, and we own our civil liberties. We only have them if we choose to act and work to keep them, and that's what I hope we do. So if you have questions about this, or I wasn't going to go through the whole thing because that's
Right.
torturous for.
I think for people who may have seen the article online but haven't seen your adjustments, maybe just go
Address.
quickly
Yeah.
through what you've changed.
Yeah, absolutely.
Can I just ask,
So
do you
Yes.
want us to ask questions of Amy now or after we've heard
Yes,
the
we can.
testimony?
No, we should do it now.
Okay.
Do you want me to, let me talk about
Yeah.
this first and then,
Yeah.
so the audience knows. And so one of the primary concerns, and the chief will, I am sure, forcefully speak for himself, but it was, being able to collect evidence with the section 8.39.2, which, by the way, these are some of the same numbers in another newly proposed bylaw, so we'll have to adjust some of those in the long run if both pass. And hopefully they will. But this idea of face surveillance system or information derived therefrom, and they were concerned about the collection of evidence around that, and it's in section 1A, or it's in 1A and 1B of that section. And so I did take that out. I don't love it. I feel like it's a big carve out, and it does sort of maybe encourage other communities to use it in some way, or it doesn't dissuade them necessarily if we're sharing information. But it's the police have to be able to collect evidence. That's there is the concern there. So I tried to address it. I thought that was a very big compromise. I don't know that that's how it was felt, but I view that as quite a compromise. And then just also there's a carve out, a new section in 8.39.2, number 2, and it's a list more or less of clarifications on what wouldn't be in violation of the law. So things like having a phone that you have to open with your face. If the police had to use one of those either personally or, take one as a piece of evidence, if they're given that as evidence, that's fine. It's an authentication process. They're not using it to identify people in that way. That's using social media, as long as they're not using it to try to identify people, any use of that, perfectly permissible. This isn't blinding anyone. This isn't preventing anyone from looking at a picture whatsoever. And it's not preventing them either from you maybe picking up a physical piece of evidence that might have surveillance on it, or the technology on it. If they have to use that as part of evidence, it seems a little, I don't know how common that is, hopefully not much, but that's okay too. No one's going to run afoul of the law with that. So and you can use redaction software, so if it's not looking for a specific face, but you want to blur a face, that's fine. Because again, it's not about identifying individuals. And I want to repeat, this doesn't touch cameras. This doesn't touch pictures. If you've got a picture and you want to look at it, you want to share it, you can do that. There's nothing in this bylaw that stops this. This is specifically about the ban of the technology, which, to my knowledge, we do not have and use. And so it is a good time, not normalize it. And that's what this is.
Thank you, Amy. Other questions? Elisa?
So
Elisa?
I do just want to clarify the change in 1B. So you are saying if Facebook had an image of a person that was derived from facial recognition software, and that is provided to the police for the purpose of identifying the subject, that is now going to be permissible? Is that?
Technically, they can look at it, right? They can't use Facebook to try to they can't apply face surveillance on it themselves, but if someone says, here's a link to a Facebook page, and this is the person we think, they can look at that, they can gather that, that's fine.
And when you're saying they can't use Facebook, what would that fall
That would
under?
mean they-
Would
they
that
ca-
fall under the conduct with any third party for the purpose? Or
That's not
an
so much
agree-
the Facebook one, that's more of so you're talking about a couple of different things. You used Facebook as an example, so
Right.
I
So the
spit
part
that
one,
back at
I've
you.
understood, that's information that someone else provides.
Right.
So and then you had also said, however, the police should not be able to go through Facebook
Or
to.
take a picture of someone, put it in, and maybe try to figure out who that is through some other site. Just not use any surveillance that would identify people, because both it's flawed and also it's a bit of a due process problem, right? If you're walking down the street, it's to identify people. I don't know if that answers.
I guess I'm just trying to understand how far you're saying that they cannot have an agreement with a third party
So
to
what-
access information that may have been obtained from a facial recognition software.
What they can't, you mean Section 1B?
Right.
So Section 1B is basically, well, let me go through, 1A, B, and C. 1A is you can't do it, Brookline. 1B is you can't ask somebody else to do it for you. So your hands are clean, but somebody else has done the job for you. And C is, and if we're going to give some sort of permit to an outside company like the e-ink people who are coming into town, they can't do it, right? If we're going to permit a third party to come in town, we can't impact people inside their places of work, right? Private use in businesses. That's a whole other problem we have to address separately somehow. But if we're going to give somebody a permit to be on our public ways, they can't use it if they have to come to us for permission to be there, to track who's going by, to keep order of people in a line.
So
to-
let's say we've identified a suspect on a camera in a building who's raped somebody, and we would like another municipality to see whether that
can't
person
farm- we can't
so
farm the dirty
cannot-
work out.
So
Right.
that would be
1B.
C, wouldn't it?
No, that would be 1B. It's not a permit. I guess technically under, or any other agreement, but really it falls under 1B. It's 1B. So, yeah, but you could use the picture. You just can't use the technology. And I don't know that you'd want to anyway. It's so deeply flawed. You could be getting wrong person or group of people. And so anyhow, but yes, that does prohibit that.
Speaking.
Not too close.
Okay. So suppose someone. Is it on?
Okay, so suppose someone is walking on Brookline streets, collapses from some sort of medical condition. They don't have any ID on them. Are the police allowed to consult with other communities to try to identify if they, take a picture of their face? Are they not permitted to do so?
They can absolutely take a picture of their face. There's nothing preventing picture taking.
Right,
There's
but then
nothing-
asking the other community to.
To say for
to
face
use-
surveillance.
Yes.
Right, no, that's
They can't do that.
prohibited, right.
Okay.
It's a loophole, right? You have to give somewhere, it's
Right.
what they've been
Or if
doing for
someone
the
with-
last however
someone
long they've
with
had pictures.
Some sort, a senior with Alzheimer or dementia of some sort is
Right.
wandering around, the police cannot use any kind of
is
system
correct.
to help identify
Right.
them.
Hopefully, the missing Alzheimer's patient, as often as that, but somebody will be looking for them, but it would be the same as it's always been, right? They have a picture, they can take the person to a hospital or wherever they do, and they can find them that way. We wouldn't acquire the system to use it or ask someone else to use the system. Yeah.
Right. So I wanted to clarify that. Essentially, what you're saying is that the information can be utilized if there's no contract for that information, if someone presents the town with information that was derived from facial recognition software, if the town hasn't contracted for it, they can accept that information? Is that what you're saying?
Technically, that's where I drove the truck through made the hole in the Warrant article to appease the chief. Yes, so that is a poor outcome in some ways. If it has been, but if it's actually done wink, wink, nod, nod, that would technically run afoul of this Warrant article, and then that's arguable. That would arguably be they would be in violation of the bylaw. If they did it,
Okay.
wink, wink, nod, nod,
One-
yeah.
But one question I have, under 1C, the very last thing says that we can't authorize a third party to obtain, possess, access, or use information derived from a face surveillance system based on photographic, video, or other images originally captured within the town of Brookline. What does that mean?
So again, that's really more for, that's the permit issue. That was the third parties who may come in and set up shop or have the e-ink, that we don't want them collecting and using face surveillance on our communities.
So is
And
that
so even if
something
they
like
do it-
Ring?
Pardon?
Is this something like if someone has Ring outside, isn't that what Amazon calls it?
That's different. It is true, and that's a real threat. It's a real problem, right? Because that's a whole other problem that this,
Well, would this
doesn't-
ban Ring?
no.
Well, what about,
You don't have to get a permit to get a Ring doorbell.
well, no, but that's what I was trying to get at before on 1C, but I guess I didn't capture that. So we've had someone go into a building and rape a woman. There's a picture that's captured on the building camera of this one person who arrived at that time. Chief Lipson is talking to Chief so-and-so from Arlington. Arlington has had a rape as well. They haven't been in the same modus operandi. They're trying to figure out who did it. They're trying to locate that person. They request from the Brookline police that picture from the camera from the building where the rape occurred in Brookline and have them run it through their, I don't know what Arlington has, but assuming, let's say they have a facial recognition system so that they can go through whatever pool of photos they have. That, I assume, would not be allowed under 1C. Is
Not
that
if they're not if
correct?
they're sharing it for the purposes of having face recognition.
No,
used
that's what
on
I'm
it.
saying, they
If
can't,
they're,
they
if
would
they
not
have
be allowed to
information that's
have
part of
that.
evidence as a crime and they're talking, it's.
No, I know. So they have we have a photo of the person who we think is the suspect in the rape here. It could not be provided to Arlington except for the purpose, well, I'm not sure what purpose it could be used for, but it would not be to help Arlington. If they had a facial surveillance system, that they
That's
could
what they
maybe
were
run
doing. I mean,
that
that's
photo
prohibited
through,
in 1B.
but not use that.
Right. You
They could
can't-
not use that
Yeah, you can't
photo.
say, here, we don't
Right.
have it, you do it for us.
No, on their behalf. They're searching for someone.
But if it's a picture from here, if it's a picture from here,
We can't provide it to them.
Yeah.
That would be under 1C.
yeah.
I just want to make sure I
1B,
understand.
1B, really. Again, 1C is more the third part. There's a little bit of overlap, but that's really the intent of 1B. 1C, again, is for third-party people coming in who have, the select board may not actually give them a permit like they needed to for the e-ink. They may be some other sort of agreement, but some third party, that one is, on our public ways doing. So now, for example, the SUFA e-ink will ping your phone. So they won't get your face, but they will have your IP address. And so they can, and which is not totally anonymous, right? They can figure out who you are, but we wouldn't let them ever use face recognition to do that or collect and give information back in that way. That is what C is about.
So this is for based on photographic, video, or other images captured not by the town, but
Right,
by
by third
this
parties.
commercial entity.
Right, who
that
have
is-
gotten a permit, a license, or other agreement to operate on our public ways
I
for
think that
whatever
would have to be,
reason.
well, if we were to go through, I think maybe I would
I'd like
see that as
to
being
sort of move
clarified.
us so that
but-
we
yeah,
can
I
hear
think so.
from
Right.
the.
I had one other question,
Sure.
and that involves process. Did you get feedback from the town surveillance committee?
I'm on the town surveillance committee.
Okay.
So,
And the committee has been totally circumvented.
Oh, wait,
That-
we
yeah,
will take that in
that's,
public comment.
I
Thank you.
wanted to.
No, I actually appreciate the question, and I definitely want to respond. So I submitted the warrant, so the surveillance technology and military type equipment is the full name. It's a mouthful of marbles. It was supposed to be created, well, 2 years ago in the spring, town meeting created that because of 3 warrant articles that were referred to the committee. It's taken a year for that committee to get off the ground. So we had our first meeting in May. In June, because the warrant article for this town meeting, as you know, is over the summer, and it was made clear to me that the petitioner who I thought might be bringing this similar warrant article was not going to do that, did not have the bandwidth. I said in a committee meeting, I have the energy to do it, I will. And so that was in June. And then over July, when we did not meet, and August, which is when the deadline for the warrant article was, and many things, happened in the summer, I submitted the warrant article. At that point, I'd put it past town council a few times. We disagree on a few things around it. But that was part of the process. And then I also sent a copy of it to the state municipal law unit to get their feedback. I did not hear anything from them, but I told them who I was. I sent emails. I made phone calls. What I was doing, and didn't get feedback. So I did that, and then this was on the committee's agenda, I think in September. And the feedback I got at that meeting, it was toward the end, and no one had a copy of it in front of them at the time, unfortunately. But I did hear unintended consequences, but no actual feedback that's incorporated here now. We had another meeting, the next meeting in maybe October. It was afterward, in which the entire meeting was about that. It wasn't actually part of the agenda at the time, but that is what we spent the entire meeting on. And the message there was mainly around process, again, not necessarily content. And then we've since had 2 other subsequent meetings where I have gotten feedback of a variety. And then I had called the chief before the select board meeting around that too, and we had talked and exchanged many emails. So, and which is where, many of the changes and carve-outs, just for clarification purposes, had come. And also the select board had asked me to make those clarifications, which I'm more than happy to do. Because again, this is more about preventing the use of this deeply flawed, deeply dystopian software. It's not about, that's what it's about in the end. So making it clear that it's okay to collect it if it's a piece of evidence, or to have an iPhone that uses your face to open, is not what this is about. This is a much larger civil rights, civil liberties issue.
Thank you very much, Amy. I'd like Associate Town Council to talk about the bylaw from, as you understand it, and what it would mean for the town.
Thank you. I'm Patty Correa, First Assistant Town Council. I don't have prepared remarks. I can touch on a few points,
Yes.
listening to the petitioner's comments, and that I have otherwise. First of all, I just want to state that the state bill that's pending is not a ban. This is not on all fours with the state bill. The state bill proposes a moratorium and a period of study. I did speak with the petitioner in July about an earlier draft. I pointed out that a few legal problems. One was inclusion of language purporting to create a civil cause of action in state courts for violation of a town bylaw. I raised a question about whether that exceeded the town's constitutional authority. I suggested she contact the Massachusetts Municipal Law Unit of the Attorney General's office. I understand they didn't connect from the petitioner's comments. I did receive a call. I did reach out to Margaret Hurley, who's director of the MLU today, left her a message. She was out of the office. She did call me back. And she did say that they have considered similar language in the past, and they do view it as inconsistent with state law, more or less along the lines of the reason that I had included in my memo. She said she was going to ask her staff to forward to me some opinions relating to this, and I haven't heard from them yet. And again, she was not in the office. One of the other points that I had raised with the petitioner in July was that I was concerned about language that's since been changed that would prohibit use of information derived from face surveillance technology, pointing out that perhaps there should be a knowing standard inserted, because certainly there could be, perpetuation of second, third, fourth generation who knows information, and you are exposing, this is essentially an employment policy, but in the form of a town bylaw, and you're exposing town employees to legal exposure by having a town policy to this effect. So there has been some changes in the language, but listening now to some of the fact scenarios, I am concerned again about not including some sort of knowing standard, because there was discussion about even I had interpreted the language here as addressing the language of an agreement, written language of an agreement, but apparently it's conceived that if Brookline were just to give a photograph to Arlington, that would fall within the ban's language, and that's not how I read it. So if that is the extent, perhaps there should be a knowing standards inserted if you're going to expose, again, town employees to legal liability. Another point I had suggested was that if you are purporting to create town employee policy through a bylaw, perhaps the better route is to simply create a policy. And there are several ways to do that. If you pass a bylaw, that's a very rigid way of regulating, and a technology that obviously is very fluid and developing, and that could have uses, for example, identifying a medical emergency victim, identifying children. There is an exclusion but it's a narrow one for the National Child Search and Assistance Act. I don't know how narrow or broad that's intended to be, but certainly I would think if you're just limiting it to one statute, there might be other uses in protecting children that would fall outside of that exclusion. So if you have a policy, for example, you could have a general order that could be developed by the existing subcommittee or a different one. It would go to the select board, and there would be a public hearing, and there would be feedback from the community to our top elected officials about what the community wants. That would provide a much more fluid way of addressing the community's concerns, addressing legal concerns. Janice had circulated a white paper from a group at Georgetown Law School from 2016. Oh, okay.
Lisa found it.
Okay. So, this group from Georgetown Law School, which is one of the top law schools in the country, didn't propose to ban it. They proposed to regulate it in a way that would address legal concerns. And so if you have, bylaw is a very clunky way to regulate, with going to a town meeting of almost 300 individuals, and this whole process. And a policy could be a much more nimble way to regulate. And so that is a point that I had raised with the petitioner over the summer. And I think those are the major points we had discussed.
Thank you very much. I wanted to also hear from Chief Lips. Maybe, okay. Oh, quickly, yes.
So just a couple of things around that. So the piece, we are in disagreement over whether or not, and obviously, we'll hear from the Mass AG's unit, or municipal law unit, but that's why there's a severability clause in my law. So, I took into account for that. And so I don't think that is, it's certainly something to be aware of, but nothing fatal. And I absolutely, this bylaw, if you look at the enforcement, it creates a private right of action, if possible, to give individuals power if they feel like it's been used against them. But nobody's going to jail over this, and they can't sue the town for money damages in that way. It would be to stop using the technology, stop the behavior. So I want to make that perfectly clear, right? This is not open the town up to litigation in that way, as far as the enforcement piece goes. Right. Well, the enforcement is about that, and it would be more around. I didn't want a policy specifically because we have policies in place now that are not being followed. And I heard at one meeting that, the fact that people knew they weren't following the policy, that was, well, we knew it, so that was okay. So I specifically, that is one of the reasons I chose to do the bylaw. I want it to be clear to people. I mean, obviously, town council has a comment based on what I just said, but I stand by the ban and not a policy. And the severability clause, I believe, takes care of the other.
Actually, while you're at it, can I just ask two more questions of Amy? Which are, one is, I know in the beginning of your presentation, you talked a lot about the fact that there are no laws in very few locations that address how to do facial recognition.
There are none at the state or federal level.
Right. And I know the Georgetown Privacy Project had a model that could be used by municipalities. And I'm wondering how you feel about that, or if you just want a cross-the-board ban without looking at
I'm really glad.
setting up
I'm really
regulations.
glad you said that, because that was a lot of the content, I think, of our meeting, right before this meeting with the surveillance technology and military type equipment hearing. And that I do feel like a ban is relevant now and what we should do, because it's the wild, wild west, and we need to make a statement. But as we know, there are many bylaws before us that we are modifying this town meeting so that there can be additional work, right? More information, as if there's some exigent circumstance type carved outs. It's not like this is done and done, right? That's not how this works. Kicking the can down the road, I think, is a horrendous idea, because, and that's why I want town meeting to be able to vote on this November. But it does not mean that there won't be, and I'm sure there will be, certainly at the federal level, right, uses. I think that goes without saying. And one other thing, it fell out of my head, but I also wanted to say, as far as the complying with the National Child Search Assistance Act, I actually put some time into that one. It's not just that particular act sort of in and its own little box. That one applies to several other related acts and laws. So it was meant to actually gives a broader reach and for that particular problem that was posed. So that's why I chose it, and there was some work involved in that. It wasn't arbitrary, and that's what that is.
So I just wanted to follow up on the regulations. As Patty Correa mentioned, the state law that's being proposed has a moratorium until a statutory framework is put in place. How would you feel about that? Instead of just a ban
Right.
without any encouragement of developing regulations, of doing a moratorium until those regulations are in place?
To me, the ban is the moratorium, and then when there's something better, we can do something with this, if that's what town meeting desires. But, it's, that's that. That, again, it's, I'm proposing it.
Right, right.
Yeah.
Could I just ask, I have a couple of questions to town council. Based on the language related to enforcement, could violation of the ban result in overturning convictions, criminal convictions?
A violation, I don't understand the question, I'm sorry.
Under section 839.3 enforcement, it says that face surveillance data collected or derived in violation of this bylaw shall be considered unlawfully obtained and shall be deleted upon discovery. And it also said that no evidence derived therefrom may be received in evidence in any town proceeding. So my question is somewhat broader. Could this be used to overturn convictions if there's a violation? Could a criminal defendant use a violation of this to throw out evidence and overturn convictions?
That would need more research, but generally, there's very limited doctrine in the law in criminal defense cases regarding fruit of the poisonous tree, that kind of idea that goes to constitutional violations.
Right, but this wouldn't be
This isn't a
constitutional,
constitutional violation, right. So
but someone could bring a lawsuit or,
anyone can bring a lawsuit for any reason.
Right.
Stating
And-
any kind of far-fetched claim. And part of my concern with including the civil cause of action language, for example, is, I mean, assuming it gets past the Attorney General's office, there is simply no cause of action. There is no state cause of action. And so you would be inviting essentially frivolous lawsuits against the town that the town would then need to defend.
well, another area of possible legal action might be wrongful termination or any kind of penalty that an employee suffers from not following the ban correctly. It does say that violations by a town employee shall result in consequences that may include retraining, suspension, or termination, subject to due process requirements, et cetera. So this could also be an area of additional litigation that the town would be exposed to, correct?
Oh, absolutely.
Okay.
And just to explain a little further where this fits into existing law, we have an Article 10 of the bylaws. Article 10 is the enforcement scheme for our bylaws. And it puts the police in the position of enforcing the bylaws. So the police is put in there's a criminal remedy as exists under state law, Chapter 40, Section 21. There's a civil remedy as exists under state law, Chapter 40, Section 21D. And the enforcement authority under our bylaws is the police and any others that are added. But you're creating an employment policy that is to be enforced by the people. Do you see what I'm saying? So I just wanted to point out where this already fits into existing state statutory law.
Thank you.
Thank you.
Chief Lipson, would you like to
Is there
comment?
someone from the ACLU here?
That would be under public comment, yes. Yes. Yes.
Who would like to speak?
Yeah,
Oh,
we'll
under
take that
public
under
comment?
public comment. Chief. Is that mic on?
It's green.
All
I
right,
think it's on.
you're on.
Andrew Lipson, Chief of Police. Thank you for having me here tonight. I have a prepared statement that I'd like to go through, but I'd just like to speak a little bit about the process first. A year ago, we had this warrant article at town meeting that had devastating language in it. It was referred by town meeting to the surveillance committee, and through this
Can
process-
everyone hear?
Or, no, can you, yeah.
It was referred to the surveillance committee by town meeting. One of the members of the committee has, as we know, filed this bylaw, and I'm going to address some of the carve-outs, but really the way things seem to have been working so far is that when we've presented a problem, we weren't consulted in the formation of this bylaw, but when we've presented problems, giving specific examples, there's been carve-outs for very specific examples. And I think it defeats the spirit of what we're trying to do here, but you'll hear more from that in my prepared statement. So, new technologies and emerging fields of use by law enforcement entities often cause concern and desire for restrictions from some members of the public and policymakers. New police technologies at times have to catch up with laws that are not current or regulations that do not, at the time, adequately address possible concerns. New technologies such as DNA, the internet, are met with early skepticism until the balance between benefits and dangers is weighed and protections are put into place. But beginning with an outright ban can lead to discarding valuable tools that at the end of the day make people safer and help those in need. There is a need for discussion of regulations, the use of facial recognition that may be desired by our community, but Warrant Article 25 has been poorly crafted and is overly restrictive and overly prescriptive. If passed as drafted, Warrant Article 25 will have a catastrophic implication for safety in Brookline and all those who live, visit, work, and travel to and from. The language of this article would create a massive void of evidence collection that would set off a chain of events that would allow increased criminal activity and likely result in the deliberate indifference to large swaths of evidence that could be used to prosecute offenders and exculpatory evidence that could protect the innocent. This outcome is untenable for public safety and criminal investigation in the town. Our police officers would be unduly prohibited from performing these duties and following through with expected judicial processes to an unprecedented extent. The rationale for this extreme objection to Warrant Article 25 is rooted in the language of the article, which will be addressed shortly. For perspective, the Brookline Police Department does not currently have or deploy real-time face surveillance and does not have software that runs face surveillance comparisons of any of our databases. The department is very actively engaged with the Select Board Surveillance and Military Type Equipment Committee to put a balanced and meaningful regulation in place to govern surveillance applications in an open, transparent, and community-involved way. These efforts mirror initiatives already completed in San Francisco, Oakland, and Berkeley, California, and are underway locally in Cambridge and Somerville. This committee, which was put into place after a similarly devastating warrant article that was proposed last year from the same national organization that is responsible for this warrant article template, should be having a constructive, thorough, and proper discussion to formulate the best outcome. Instead, this article was initially crafted with no consultation with the police department or the committee, and what I believe was a deliberate attempt to circumvent a collaborative approach until the last minute. Crafting warrant articles in this manner may bring the prestige of being the fourth or fifth community to pass and ban, but we should be striving to do what is right by meaningful collaboration and consensus. This is something that has recently been hammered home for us with the Public Safety Act, which is in the process of being pulled and was referred to the Surveillance Committee for further review. In neighboring Somerville, a ban was passed with a similar template of Warrant Article 25, with zero effort to have input from the police department, despite the fact that they're also engaged in a robust policy-forming process surrounding surveillance. This is a deliberate tactic employed to rush ordinances and bylaws past overburdened police and municipal services without giving them the time to form a coherent and thorough testimony. We should work to do what is right, and not just so we can have the distinction of being the second municipality in Massachusetts of having a ban. This is particularly true when there's not a plan to implement town-owned facial surveillance systems in the town. The petitioner has now heard some of the concerns of the police department and has attempted to make substantive changes. However, the changes do not solve the problem that this article would create. The main flaw in the article is the devastating effect it would have on the collection of evidence. Police cannot be restricted from collecting broad categories of evidence that exist in the world around us. Warrant Article 25 does nothing to prohibit the existence of private or non-jurisdictional face surveillance systems from existing in the town or the municipalities around us. The proposed article states, "It shall be unlawful for Brookline or any Brookline official to obtain, possess, or access or use any face surveillance system." So what are some of the face surveillance systems that are commonly used or possessed in the world around us? And probably many of you or your children use them. Examples include iPhones, iPads, Snapchat, Facebook, Apple iPay, an array of access control and second-level authentication applications. Applications can be put into Tesla vehicles to allow them to open with face surveillance systems. The Brookline police must not be prevented from possessing or obtaining these items in the performance of their duties. New technologies are coming out on a regular basis that we can barely keep up with. The examples can go on and on. Human traffickers, burglary suspect, hate crimes, all having crucial evidence carved out from collection due to the language of this article. This would be a huge mistake, and I'd like to believe this is an unintended consequence of this article, but it has been presented to the petitioner at the Surveillance Committee, and she at times seemed unmoved. Very narrow carve-outs have been made as a result of specific examples we have raised before the Surveillance Committee. These carve-outs are too narrow and do not solve the problem of the evidence collection problem. They would also create a dizzying and confusing process for our town employees, police officers and detectives, as they encounter emerging technology in the performance of their duties. They will inevitably be presented with evidence and left wondering if they can look at it, possess it, collect it, or should destroy it. Police officers should not have to guess while processing a crime scene. The implications are too severe. Please consider a couple of scenarios, and one of the scenarios I provided is similar to a question that was asked about Facebook. But so a police officer responds to a violent home invasion during which multiple suspects barged into a home armed with a handgun, assaulted the occupants, held them at gunpoint, and demanded money and drugs. One of the victims recognizes one of the suspects from Facebook, but doesn't know their name. The victim shows the responding officer a picture of the suspect on Facebook from a, quote, tagged photo. The officer and responding detectives then use this image and subsequent search warrant via Facebook to identify the suspect responsible, which leads to an arrest of the other suspect. Facebook uses face surveillance to tag people in photos, and under the proposed bylaw, the actions of the officer and investigators would be illegal. In fact, the investigator would be required to destroy the evidence. What if the initial responding officer is not aware that face surveillance is involved in the application that they've collected as evidence? Have they unwittingly violated a town bylaw, and legal action can be initiated against them? Another example, a student at BHS brings an application to their guidance counselor and says that the application shows a student who sexually assaulted them over the weekend. Does the guidance counselor have to stop and try and determine if the application uses face surveillance? If it does, do they refuse to look at it and not alert the police? If they unwittingly collect it and the police arrive and the guidance counselor gives the detective the video and the detective knows that the application involves facial recognition, would the detective be required by law to destroy the evidence? Death investigations in the town of Brookline are the jurisdiction of the police department and the investigators from the state police who are assigned to the district attorney's office. Some of these examples that you gave, the State Police Fusion Center uses facial recognition. I think under a number of these investigations, the Brookline police would have to remove themselves from these investigations, which would create a huge problem.
Could you clarify that?
Well, if they're going to use investigative tools under agreement with the
No,
district
what
attorney's
was
office.
the organization or the tool?
The state police assigned to the district attorney's office, any death investigation that occurs in the
okay.
town of Brookline. So we haven't had a homicide, fortunately, in a long time, but there are, every year, there are many death investigations, unattended deaths, overdoses, suspicious deaths, deaths of children and young people that are investigated as a homicide would be investigated jointly between investigators of the state police and Brookline police detectives. Brookline police detectives are the people who know our community. They know who the people are, they've worked with them, they have the connections. Separating those two streams of investigation due to a bylaw like this would be really unfortunate. Also, in the Arlington example that you used, which I think is a good one, so an image, there's a lot of loopholes that could happen there. The same suspect, which happens frequently, commits crime across jurisdictional boundaries. A photo is captured in Brookline and then distributed to our law enforcement partners of the suspect. The suspect continues to commit crimes in other jurisdictions. Another jurisdiction gets our image and runs it through facial recognition software and comes up with a suspect. And they go and they capture the suspect. Are we precluded from using that information in the prosecution of that suspect? Does that suspect then not get prosecuted for the crime in Brookline, but only for the crime in the other communities? What if that person has committed multiple crimes in Brookline, but is only going to be held accountable for the crime used in the other jurisdiction because our detectives can't rely on that information? It really creates a huge area of trouble. Clearly, all of this is ill-advised and would create untenable, frustrating, and confusing circumstances for all involved. Take a step further back and think about scenarios where the evidence would be exculpatory to someone who's accused of a crime. The surveillance bans in Berkeley, San Francisco, and Oakland do not contain this language. Berkeley's ordinance on surveillance specifically states, and I quote, "Evidence relating to the investigation of a specific crime that may have been generated from face recognition technology but was not initially solicited shall not be a violation of this ordinance," end quote. It is a shame that at this late time in the town meeting process, this is where our discussion rests. There's not a need to rush into this language, but there is a critical need to get it right. The ACLU, in their letter to the Surveillance Committee, references the importance of the 14th Amendment due process rights. They state that some police departments have been too vague in how face surveillance has been used in investigations, and it has created a situation where defendants, therefore, are unable to challenge evidence and have a fair trial. I would suggest that creating a broad category of evidence that will be ignored only by Brookline police investigators and will not be collected not only is unfair to victims, but would preclude defendants from having a fair trial. Exculpatory evidence will be lost, or worse yet, prohibited from being collected by local law. 14th Amendment due process cases have generally ruled that police cannot be held liable for a failure to collect evidence or for destroying evidence unless there can be a showing of bad faith. If we're going to have a bylaw that says officers cannot collect evidence for no other reason than it exists on certain platforms, how long until we are challenged for due process violations of those convicted of crimes whose exculpatory evidence was deliberately ignored? Categorically eliminating the ability of our police department to obtain and possess certain categories of evidence because they fit the Brookline definition of face surveillance system would be outrageous. This language is so damaging, and the discussion has been too limited in time and scope so that we've not had much time to discuss other issues that occur later in the Warrant article. There are equally devastating language pieces around Warrant Article 25. This subject deserves careful review. We can have policies and regulations in town that protect from the threat of surveillance and disparate treatment without upending the rules of evidence. This language has also distracted from what should be a thoughtful discussion of when the community may want to use facial recognition. There are a number of community caretaking functions that would benefit greatly from careful applications of facial recognition. People who are found deceased, suffering medical or mental health emergencies, who are unable or do not have any form of identification, could be much more quickly identified. A wandering Alzheimer's patient could be quickly reunited with their family. There are numerous applications for missing and exploited children that occur on a regular basis nationally and can do impact us here in Brookline. We should not unplug or restrict ourselves from these resources while facial recognition applications grow around us. We must share information with outside resources under the right guidelines. There also may be criminal investigations that warrant the use of facial recognition applications. When police have a quality photo of a person who committed a crime, facial recognition can be used to create an investigatory lead. This does not mean, as the petitioner has suggested, that a person has been identified as being responsible for the crime or subject to immediate arrest. Investigators would instead use the information as one part of an investigation, similar to a tip or an eyewitness photo recognition. Also going unmentioned is that the technology is improving over time, and there are indications that problems of misidentifying certain genders or skin tones will be corrected if they have not already. More recent studies by the Florida Institute of Technology and the University of Notre Dame in 2019 indicate that some of these concerns may already be going away. DNA evidence was highly controversial in its introductory and early stages, but has gone on to become a key category of evidence through development and careful regulation. DNA has become a key tool in reversing many wrongful convictions and in exonerating many who have spent years in jail. Many of these prosecutions were the result of convictions based on flawed eyewitness identification procedures. Proper collection and processing and presentation of scientific evidence were essential to these developments. The Brookline Police Eyewitness Identification Policy, approved by the Select Board in 2017, follows best practices to prevent such miscarriages of justice. The policy reads in part, I quote, "Erroneous eyewitness identifications have been cited as the factor most frequently associated with wrongful convictions. Therefore, in addition to eyewitness identification, all appropriate investigative steps and methods should be employed to uncover evidence that either supports or eliminates the suspect identification." End quote. We are doing victims and defendants a disservice by not collecting as much evidence as possible. Whether we use face surveillance evidence now or not, banning it from being collected when it exists in the world may be eliminating the possibility of reversing a wrongful conviction, because in the very near future, if not already, face recognition technologies, disparate deficiencies will most likely be eliminated. Clearly, there are numerous concerns about the uses of facial recognition. Excuse me. And appropriate rules and regulations deserve careful and thorough consideration. This Warrant article has far too many sweeping negative impacts outside the scope of what it purports to secure. Passing this article would be a massive mistake for the safety and fair and impartial policing of our community. The police department is currently working collaboratively with the Surveillance Committee to develop thoughtful, thorough guidelines for the use of this and other technology. This warrant article is premature and in contrast to the will of town meeting, which voted unanimously to create the study committee.
Thank you very much for your comment. This is a topic that has not had broad community discussion yet, and so this public hearing is being televised. It's being recorded. So I'd like to open it up to the public comment period. This is a public hearing, and would like to start with the ACLU people who are here. Thank you very much.
Thank you. Good evening. My name is Kate Crockford. I'm the director of the Technology for Liberty program at the ACLU here in Massachusetts. I'm happy to be standing here representing our 4,000 members and supporters in the town of Brookline. I think probably some of them are in this room right now. I hope maybe some of you as well. I appreciate actually that the chief in his comments ended up disclosing that he believes that face surveillance is a technology that the Brookline Police Department wants to reserve to use in criminal investigations. I think that's a really important piece of clarifying information, because I have been confused throughout this process about some back and forth between Chief Lipson and Amy Hummel and others involved in the surveillance committee. The chief has raised significant concerns and objections throughout this process, and Amy has gone through the text to address those concerns, many of them at least. Specifically, I think maybe some of the chief's testimony that he just gave was written prior to some of these changes in the text. For example, the idea, I heard in the back and forth between you and Amy as well, the idea that this bylaw, as it's currently written with Amy's changes, would prohibit a Brookline police official from sharing a photograph with somebody in Arlington strikes me as not remotely true. And
Well,
if the police department said to Arlington, hey, we have this photograph, and because of this bylaw, we're not allowed to run it through a facial recognition system, we would like you to do that, that certainly is prohibited by the bylaw. The sharing of a photograph is not prohibited by the bylaw. So I just want to be very clear about that. Second, it also seems like the chief is reacting to a prior iteration of this language when he says that the bylaw as written would prohibit his police officers from possessing imagery that comes from a facial recognition system. In fact, the language that discussed the possession of information derived from a facial recognition system or a face surveillance system was taken out. Amy took it out because the chief had raised significant concerns about, and I think justifiable concerns about, town employees' ability to divine whether or not this information had come originally from a face surveillance system. They're not mystics, right? And I think that point was well taken, so the language was changed. I just want to be clear about that. As written, the bylaw does not prevent the Brookline Police Department from working with state police on a death investigation. Did you have a question about that?
no, go ahead.
Okay. So I just wanted to also react to a few more things that the chief said. I think the comparison of this technology to DNA is instructive for two reasons. One, we are not satisfied, and that is to put it very mildly, with the state of the law on DNA. Right now, the Supreme Court, a decision the Supreme Court handed down a couple of years ago, basically says that law enforcement across the country may collect someone's DNA subsequent to an arrest. Okay, so that is a very bad standard, actually. The FBI has amassed huge quantities of DNA from people all across the country, and right now, you probably saw in the news this week, the Trump administration would like to start collecting DNA from asylum seekers, which is just a horrifying human rights violation. So, the idea that we should look towards DNA as a model with which we should consider, how to treat facial surveillance in the 21st century, I think is a frightening idea, actually. The other reason it's different from DNA, this technology, or I think the DNA comparison is instructive, is because in order to collect my DNA, Chief Lipson would have to send one of his police officials around following me to pick up my cigarette butt or my coffee cup or pluck some hair from my head. That means that this technology, DNA surveillance technology, requires a degree of presence and engagement and time and resources from law enforcement officials that actually can help to protect the appropriate balance of power in a free society between the people and the government, which is to say that the government ought not to be in our business, frankly, at all, unless they have a good reason to believe we're up to no good, and in most cases they should go to a judge and show that, which is called probable cause, of course, and get a warrant before violating our privacy. This requirement with fingerprints and DNA of some physical proximity to the person who's being monitored, whose information law enforcement seeks, is a critical bulwark, actually, against mass surveillance. It is not possible, in other words, for law enforcement, either here in Brookline or at the state level or at the FBI or at ICE or any other agency, to collect my DNA through a video surveillance camera. They cannot collect my DNA through, or my fingerprints rather, through a video surveillance camera. However, face surveillance completely removes that limitation, and the Supreme Court has actually spoken precisely about this in language that I think is really illuminating for this conversation. So just last summer, in a case called Carpenter versus the United States, Chief Justice Roberts handed down a powerful defense of privacy in the digital age and said that, contrary to claims that law enforcement had been making for decades, actually, we do retain a privacy interest in public. This case had to do with the government's ability to obtain what's called cell site location information, so essentially information your cell phone company is storing about where you were last month, last year, etc. Law enforcement for basically 3 decades had been obtaining this information without warrants. The ACLU took a case up to the Supreme Court and said, yeah, we don't think so. This is certainly a search, and it is a privacy violation. The government ought to get a warrant to find out where you were last week by asking your phone company. Chief Justice Roberts agreed and in fact said explicitly, the notion that we do not retain privacy interests in public cannot exist in the 21st century, where technologies like cell phones enable the government to, from a desk somewhere in D.C. or suburban Virginia, track not one person's location, and not in real time, like with a police officer spending a lot of time and energy and resources from a department following Amy around town, hiding behind stuff, making sure they don't see her, she doesn't see them, but able to actually track everyone in this room, everyone in this town, everyone in the state, and everyone in the country, not merely in real time, but also to do something that was not possible before cell phones were invented, which is to tell us where Amy was last week, before she was even under investigation. And that is exactly what this technology facilitates, except whereas 2 things distinguish Carpenter from this cell phone tracking case from face surveillance. One is that you can leave your cell phone at home, right, if you want to go get an abortion and not be tracked by the cell phone company who's probably selling that information to all manner of sketchy people. You can leave at home if you want to go to a protest and not be worried about being unlawfully tracked by the FBI. You cannot leave your face at home. We are entering a new territory where these types of surveillance that use our physical characteristics are just qualitatively different from the types of surveillance that we talk about when we think about things like cell phone tracking. And another distinguishing factor with cell phones, and this is really crucial, is that, first of all, you have to get a warrant now to be able to conduct that tracking. But second, the warrant is actually meaningful, because who has that information? It's not the police. The police are not going to a judge to get a warrant to serve the warrant on themselves. They're getting a warrant and serving it on the phone company, which again is another level of friction, right, that protects the public's interest and protects against misuse and abuse. In this scenario, what we're really talking about, and what is already happening in places like Detroit, and Chicago. The New York City Police Department has looked into this. It's certainly happening in China, where the Chinese government is using this technology to great effect to control and oppress the Uyghur Muslim minority population there. This technology, the end game really, if we don't stop it, is that every public surveillance camera in Brookline and across Massachusetts and across the country will be injected with powerful artificial intelligence technology that facilitates the kind of mass tracking that I'm talking about in public space, not of one person, but of every person, and not on one day, but on every day, and not merely because you're suspected of a crime, but merely because you're walking down the street. The reason the carpenter analogy with cell phone tracking falls apart here is, again, because who's going to control those networks? It's not some independent entity, independent of law enforcement. It's law enforcement itself, right? I mean, the chief said it. The Commonwealth Fusion Center, a very shadowy post 9/11 Department of Homeland Security funded institution that has been subject to zero oversight or scrutiny or accountability from the state government, may very well be creating that kind of system right now in Massachusetts, and we don't know about it because, frankly, they refuse to respond to my public records requests, and I'd probably be the one to tell you about it. Okay, so I've said a lot in response to the chief. I want to say a few more things, which is that this technology is fundamentally dangerous when it works and when it doesn't. We have seen, for example, in recent years, the chief has argued that the technology will get better. That's not actually what the experts say. The experts say that there is a conflict between overall accuracy for the entire population and the reduction of bias. That, in fact, when you tweak these systems to make the bias go down, you actually increase the level of overall inaccuracy and vice versa. So the idea that we're going to live in some perfect utopia of 100% successful face surveillance in the future is actually not what machine learning specialists who think about this stuff are saying. Second, in places where governments are actively testing this software in the field, in the wild, on crowds of people, so the United Kingdom is a good example. Some reports that have come out of the UK in recent years show that this technology is just an abysmal failure. And I think, even the example that you gave, forgive me, I don't know your name.
Elisa.
Even the example that you gave about, somebody walking into a building and they are potentially a suspect in a rape, I think speaks directly to these inaccuracy problems. The accuracy rates for a lot of these systems we see coming from tests where someone is standing facing the camera, full front facing, in a fully lit environment with a high-powered digital camera. Those are essentially the best possible conditions, right? Those are not the real-world conditions that we are seeing this technology used in. And I'll give you an example in 1 second about how devastating that can be, or actually 2 examples, to people's individual material lives. But suffice it to say, in the UK, they've tested the technology in the wild, and they found error rates, these are not success rates, these are error rates of 91% and 98%, respectively. So those are extremely high error rates. We saw in Plymouth, Massachusetts, we filed a public records request with the Plymouth Police. We got some documents back showing that they were just on the precipice of entering into an agreement with a face surveillance company to build that kind of Chinese-style system of using face surveillance technology on all the public cameras in town to identify people who were wanted by the Plymouth Police. And the person who was selling this technology, as a selling point, said, I think it'll probably work about 30% of the time. Now, he was selling it when he said that. Of course, when we see it actually tested in the UK, the error rates are significantly higher than that, 91 and 98%, respectively. I also just want to respond to one thing that that someone on the committee, I can't remember who, said about Georgetown. The Georgetown Center on Privacy and Technology has put out 2 subsequent reports in May of 2019 where they've actually revised their recommendations and they've called for a moratorium because essentially the technology has not gotten better. They have seen in the intervening years police departments, including the NYPD, doing truly disturbing stuff, like, for example, in an entirely unregulated space, seeing a surveillance camera image from a bodega robbery of a guy. They ran it through the system, couldn't get any matches. And then one of the police officers in the unit said, you know what, he kind of looks like Woody Harrelson. Took a picture of Woody Harrelson, ran it through the system, got a match, arrested that guy. So these are the kinds of things that can happen, and I do encourage you to read both of those new reports that Georgetown put out, because they're much more up to date, and they contain some truly disturbing information about how this technology is being used now by police departments across the United States. Okay. Sorry, there's a lot to cover. Finally, I would just say that the use of this technology is actually occurring here in Brookline. So we filed a series of public records requests with the Registry of Motor Vehicles, and they did not respond. You may have heard that the RMV has some problems with transparency. Well, it's true. They did not respond to our requests, so we had to sue them, unfortunately. And we have been pouring through literally thousands of pages of documents in response to those requests that have told us some pretty disturbing things. Among them, that over the past 3 years, we didn't get documents for the past 13 years, even though that's how long the RMV has been allowing law enforcement agencies in Massachusetts and nationwide to use our driver's license and state ID system as essentially a perpetual lineup. We did learn some things about its use for the past 3 years. We are not machine learning technology, so we can't analyze that much data. And what we found is that absent any rules, any state oversight, any oversight at any level of government, any external accountability, the RMV has not once conducted an audit of its system to determine whether or not anyone internally at the RMV or any law enforcement actors externally have used the system improperly. So we just don't know. But we do know because we got access to some handwritten logs documenting each search that the RMV performed on behalf of someone internally or on external law enforcement sources, or partners rather. Many of those logs say Detective so-and-so, so-and-so police department. A few of them just say the word Karen. That's it, just Karen. So that's an indication to us that there's abuse taking place, either for personal reasons, for political reasons. Maybe somebody named Karen at the RMV wanted to know who her daughter was talking to on Facebook, ran the image against the database. It's indicative, though, of a problem that impacts Brookline, which is that there is no one minding the store at the RMV. It's not as if you all can outsource the accountability to the state government, because there is none. We found that the Brookline Police Department has queried this system 7 times, or did query it 7 times between 2016 and 2018. And I think that's troubling, especially, as the chief said, given the conversations that the surveillance group has been having. It's my understanding that folks in that group were not aware of that. So it seems like some of these issues are not actually being fully disclosed or fully aired in that committee. Another problem, and this is a critical problem, is that criminal defense attorneys and criminal defendants have not been given an opportunity to even understand that this information has been used in ways that eventually led to an arrest, a conviction, or rather a prosecution and conviction. We did raise significant concerns about the due process issues here. The chief characterized those concerns as being about law enforcement's vague attitude. It's not actually, we're not concerned about anything vague. We're concerned that police and prosecutors are not informing criminal defendants that this information has been used effectively as a digital witness in a case against them. And that is a due process violation. People, just like if it's a human witness, people should have a right to interrogate every step of not only the technology's development and understand whether the particular tool used by the government has been subject to any accuracy or bias testing and what those results looked like, but also understand what the analyst who performed the search did. What was the procedure? What confidence threshold or accuracy level was the technology set at when it returned an image of my client or of me? What steps did you take? What investigative steps did you take next? How many images were returned? Was it just me or were there others? And who are those people? I'd like to investigate them. You can see that, there are many reasons why a defense attorney might want this information. They haven't been given this information at all. We've had conversations with our friends in the public defender's office, and when we started to learn about the extent to which state and local law enforcement in Massachusetts have been using this tool for so long, they were frankly shocked, like jaws were hitting the floor, because they also view this as a significant due process problem. I'll say two more things and then wrap up because I know we have a long night. The first is that it's not just the problem with essentially hiding this information from criminal defendants is not merely that the defense does not have an opportunity to mount a significant or an adequate defense and therefore is denied access to a fair trial. It's also that the courts are denied, and therefore the entire community and the entire state of Massachusetts is denied the opportunity of independent judicial review of these systems. And that's why we haven't had any. We haven't seen courts examine these questions because the information is essentially being kept out of the courtroom, which is a very significant problem in terms of the law reform, not merely the individual rights that are impacted. So I just want to close by saying that there's been a lot of talk about how dangerous this bylaw is, how it could, potentially harm individuals. I want to tell you two stories about people whose lives were radically harmed by the use of unregulated face surveillance technology. The first is a man by the name of Steve Talley, who was a financial analyst in Colorado. He was shocked to be violently arrested in his driveway some years back and charged with bank robbery. He definitely was not a bank robber. He was a family guy. Suffice it to say, many years later, he had beat back these charges. He had learned that he was originally fingered as a suspect and actually prosecuted on the basis of an error in a facial recognition system run by the FBI that the police in Colorado had used. He lost his job. He lost his house. He lost his kids. His marriage fell apart. He's a homeless man talking to a reporter a few years back when he said, essentially, a face recognition error ruined my life. The absence of oversight, the absence of any meaningful system of checks and balances allowed for this serious abuse of my rights to take place. This is something that we are extremely concerned about, that, it may be the case that Chief Lipson would never do something like this, but that in a future, under a future police chief or someone acting independently of Chief Lipson could act on the basis of information that's wrong and really harm someone. And the second example is actually more recent, just from a few months ago, after the horrific Easter bombing in Sri Lanka. A young woman who is herself Sri Lankan but goes to Brown University woke up to a slew of phone calls and text messages on her phone from people back home in her home country of Sri Lanka telling her, your face is all over the news. They're saying that you're one of the terrorists. And that was a result also of a mistake in the Sri Lankan government or police face surveillance system. It was eventually taken down. They eventually apologized. That was not before she received death threats. Her family at home were receiving death threats. It was a profoundly disturbing and shocking experience for her. So I just want you to know that there are serious material harms that come from the use of this technology in its unregulated state, and that is not even getting into the very many serious civil rights, civil liberties, privacy, free speech implications that I think Amy already addressed. So if you have any questions for me, I'm happy to answer them, but I know I talked for a long time. So.
Yeah, I appreciate the people who have spoken already to just frame the conversation and really add some meat, I think, to the issue. So I'm very grateful that you're here and speaking.
Actually, I do want to ask one question about the misidentification, though. Sorry, I'm trying to, I know a lot of the discussion for you has been misidentification with facial recognition software. I've spoken to experts in the field as well, and they say that actually the accuracy is better than the human eye, which also can certainly make sense to me as well. There's lots of misidentification that happens with eyewitnesses. And I guess, how do you respond to the question, here's another tool that can be used either to exonerate or to provide reinforcement of
Yeah.
human identification.
Yeah, that's a really important point. So two things about that. One, I'm not sure who the people are who you talk to, but if they're trying to sell this technology, they're not independent. So
Well,
that's one thing.
they're not, but they're.
Okay, great.
No, they do work, but they're also, they are world experts in pattern recognition, but anyways, yeah.
Well, experts disagree, and it turns out
They
that
disagree,
the experts
right.
who do not work for companies that are selling this
Right.
technology.
Anyways,
have different things to say about it.
regardless, right.
Regardless, the idea that, human identifications are bad is obvious. I mean, the ACLU has worked on that issue for a long
Right.
time. We're talking now, though, about cases in which we have photographs of people. So we're not actually talking about human identifications. Law enforcement still relies on witness identifications in cases where they don't have videos, right? So we're not, I think those are really very distinct issues, and I just want to be sure that we separate them because there is no overlap. We're not talking about like a facial recognition system says Amy's Amy, and we have a photograph of her, and we show it to the jury, and the jury
No,
says,
but what
Amy's
happens is
not
you
Amy.
get a photo of Fred, and then you want to go through all these mugshots, and it's either the human or the facial recognition software that's going through the mugshots.
Yes, absolutely. That's absolutely true. And that, again, raises significant civil rights concerns when the algorithms themselves are proprietary and the companies that are selling them to law enforcement do not want them to be opened up to courts of law so that independent experts can test them. You can put a police officer on the stand, right, and ask him questions about his racial animus or his history of alcoholism or how much sleep he had the night before. If you can't put one of these algorithms on the stand, you are automatically, putting defendants at a disadvantage because the technology is essentially unimpeachable, right?
Right, well, again, that's another issue. I mean, you could have there's always studies, NIST does all these analyses of different systems and their levels of accuracy. So that could be a tool that we need to regulate to get it there.
Right.
But I was talking more about the misidentification issue, which can happen when a human does it or
Right.
when software does it.
Yeah, I mean, it is not our view that human identifications are great in court. Certainly not. It is certainly our position that automating some of the biases that exist in human beings and then shielding the product of that surveillance from defendants and from courts, and frankly, doing it without any legislative authorization, absent any public debate. I would like to sort of flip the chief's idea about process here back on him and ask why he didn't come to the town before they started using this technology to have these robust conversations about what a democratic process would look like before the town began to use surveillance technology like this. So, I think those arguments definitely cut both ways, and,
Right. Yes, okay, Kate. Thank you. I think Chief Lipson just wants to respond to whether or not we're actually using surveillance technology in Brookline.
great. Well, I was referring
Yeah.
to the use of the RMV system, to be
Yes.
clear.
Okay.
7 times. Thank you.
Thank you. 7 times.
I just wanted to specifically answer the question. A, I wasn't chief, and B, we are having those conversations now with the surveillance committee about regulations, about what we do and how we do it. Okay. Thank you.
Thank you. All right. I would like to open it up to public comment. Could you please, I know we've spent long times letting people talk for long periods of time. I would like you to please try to be brief. Come to the mic, identify yourself, and if you can limit your comments to 3 minutes, that would be ideal. 5 if you definitely need an extra couple of minutes. Thank you. Yeah.
I'll be way less. I'm Neil Gordon, Precinct 1 Town Meeting member, member of the Advisory Committee. I'm also Secretary of Brookline PACS. Speaking this evening on behalf of Brookline PACS and the Brookline PACS Board. The Brookline PACS Board met several weeks ago and voted to support on a preliminary basis the petitioner and this warrant article. We see it as an important civil rights issue. It's a preliminary endorsement. We've not seen the final warrant article, which will be out shortly before town meeting as a result of this process. I want to speak a little bit about the PACS process and how firmly PACS and the PACS board feels about this particular issue. If you're familiar with the process that PACS goes through, we have town meeting typically twice a year. Town meeting in advance of town meeting, and at the end of the process before town meeting, we receive combined reports which have as final a version of warrant articles as we're going to see. They also include the opinions of the various boards and committees and commissions that may have reviewed those warrant articles and weighed in. The PACS board waits as late as possible in that process to meet and make recommendations on warrant articles, because we want to have all of that information available. We meet as late as possible so that our recommendations can get in the hands of town meeting members and no sooner. We made a significant exception. I'm not aware that we've done this before. Marty Rosenthal, PACS chair, speaks often. It is an unusual step for the PACS board to get out this far in advance and take a position. We see that as this warrant article as important. We see this issue as important as a civil rights issue. I'd like to add, speaking for myself, with respect to process. I like the process that we have in Brookline of town government. And the town meeting process doesn't require going through a committee. It doesn't require going through an elected official. It doesn't require permission, consent, or advice from anybody. It takes 10 registered voters in Brookline to sign a petition and bring it to town meeting. That's what happened here. This is the process. The process is going on right now, and I thank the petitioner for bringing that warrant article.
Thank you very much. Next.
I'm Susan Howards. I'm on the Surveillance Committee, and I'm also a criminal defense attorney in the town of Brookline. I have two things to say. Chairman Green appointed a subcommittee of the Surveillance Committee to make recommendations and to study the warrant article. The subcommittee met today for the first time, and we will be presenting some sort of a written document for you to review. The consensus of the committee was not across the board, but it was that there should be a moratorium to give the committee the time necessary to study all of the complicated issues that you have heard about today. That's number one. I'm just being really, really brief. Number two, as a defense attorney, I'd like to take issue with, I think, Kate from the ACLU. If defendants are not getting the proper evidence, or if prosecutors or police or whatever, that's the role of the defense attorney. There are procedures in place in court for us to demand discovery, to keep demanding discovery. There are court orders. You can't put this on law enforcement. That's my job to argue zealously on behalf of my client. Thank you.
Thank you very much. Thanks.
Good evening. I'm Jessie Mermel. I'm a resident of Precinct 12. I'd like to just speak briefly in favor of a facial recognition ban, and of course look forward to seeing the final warrant article that makes its way to town meeting. I will echo the comments that have already been made, expressing deep concerns about the deficiencies in this technology related particularly to women and people of color. I'd like to specifically emphasize my concerns around what this does to immigrant populations in and around Brookline. I think we're all horrifically aware of the environment in which immigrants, particularly undocumented immigrants, are living these days, and the stories about immigrants, undocumented or not, facing deep fear, leaving their homes, taking their children to school, going to the workplace, and what they might encounter from immigration enforcement officials. And I shudder at the idea that immigrants living in our community who might work here, who would want to do business here, would in any way fear that their safety and their ability to remain connected to their families might be jeopardized simply because Brookline is not protecting them. Another point I'd like to make relates to the day job I've been at for the past several years. I've been the president of an organization called the Alliance for Business Leadership. We're a coalition of progressive business leaders who share this crazy idea that social responsibility and sustainable economic growth go hand in hand. And while we haven't taken a position on this particular warrant article, we have taken a position in favor of the related piece of legislation at the State House. And I want to share with you why that is. There has been, I think, increased unanimity in the business community in recent years that discrimination is bad for business. Look at the way the business community, particularly in Massachusetts, has rallied around marriage equality, or Question 3 and the rights of our LGBTQ neighbors, or even the huge letter to the editor and ad taken out in the New York Times several months ago where the business community stood up for Roe and said that women can't be discriminated against because of whatever reproductive health care they might need. This is discrimination. Facial recognition technology, particularly as it currently exists, is discrimination. And if we want to make sure that Brookline is a good place to do business, to travel through in order to get to your place of business, or simply to live, it is essential that we are making sure that we are fighting discrimination at every turn. And to me, and I know to the incredible business leaders that I've had the privilege to work with at the Alliance for Business Leadership, this is a significant part of that, and making sure that we are not adopting technologies that expand opportunities for discrimination and therefore hamper our ability for our economy to grow and thrive. 10 years ago, when I was on the select board, the idea of surveillance cameras came to us, surveillance cameras that were paid for by the Department of Homeland Security, and later the idea of license plate scanners for the police. And I opposed those measures both times, but said that I had at least some measure of ease because I knew that regulations were in place that at least gave us some part of protection to make sure that people were operating within a few regulations, right? And I don't feel that way with this. This is so new. This is so unregulated. We are so early in the adoption of this technology that I don't have that same measure of comfort that even though I opposed it, still felt a little bit like, okay, well, there are people, to use Cade's term, minding the store. It doesn't feel like the store is being minded here, and I would urge the subcommittee to support favorable action on the warrant article.
Thank you very much. Next.
Hi, my name is Christopher Post. I'm an attorney. I practiced in criminal defense for the past 7 years. I live on Center Street in Brookline. First, I want to say that the ethical arguments in favor of a ban on this technology are both clear and compelling, and it doesn't really require much discussion. I want to talk about a couple of economic and legal issues. The first is that I've seen studies indicating that there's a potential error rate of up to 35% for certain minorities and genders, and I hadn't heard the figures that the ACLU cited tonight, but if it is indeed possible that some of these technologies have an error rate of anywhere between 91 and 98%, I don't foresee this ever passing muster under Daubert versus Merrill Dow Pharmaceuticals or Commonwealth v. Lanigan. And for the non-attorneys in the room, that's the threshold for scientific evidence to be admitted in court. I think one of the panel members was worried that if we did not use this technology, it might result in a reversal of convictions. What I'm trying to alert you to is the legal challenge that the use of this technology will present, and it will very likely lead to the dismissal of cases as a result of the fact that it is currently substantially scientifically unreliable. The second issue that I'd like to raise is particularly because of this disproportionate impact on minorities, you may be opening yourself up to a civil rights lawsuit under 42 U.S.C. 1983. Even though the police department has qualified immunity, the fact that they may be well aware that 1 in 3 African American women that they arrest based upon this technology may be incorrectly identified, I think opens you up to the possibility of a suit, and it may very well survive summary judgment. So the moral and ethical issues aside, I think at this point in time where the scientific technology has not been proven to be reliable. It just doesn't make economic sense for the town to sort of engage in its use. So thank you.
Thank you very much for your comment.
Good evening. I'm Casey Hatchett. I'm a town meeting member for Precinct 12. I'm also a member of the Surveillance Technology Military Equipment Study Committee, and in full disclosure, I'm also a Brookline Police Sergeant. Again, as Chief Lipson commented last spring, the town meeting voted unanimously on 3 articles related to surveillance and military equipment. Because of that, we have a study committee was appointed by the Select Board, and since myself and the other members of this committee have been meeting regularly, monthly, to review current technologies, equipment in use, to consider potential technologies going forward, their impact, issues of audit, restriction, oversight, and how to balance our technological world with civil liberty considerations. This warrant article violates the will of town meeting by circumventing this process. It was a unanimous vote to put in place this committee to study exactly what this article is looking to ban. The warrant article is at best premature and does feel like its intention is to circumvent process. In addition to the timing, I share Chief Lipson's concerns, grave concerns about outright ban, and it could affect the ability of law enforcement to investigate crimes, protect victims, exonerate innocent persons, and prosecute criminals. There's been a lot of discussion at our committee about the concerns of not having a thorough and thoughtful process in place to review these technologies, not just facial recognition software, but others. This morning, I met with a subcommittee of our committee, myself, Scott Ananian, and Susan Howard, who spoke previously, and we're working on language, which we will put to discussion and a vote at our meeting next Wednesday. And the recommendations that we'll be coming forward with include things like supporting a town-wide ban for the town and the school, an exception for law enforcement until this committee conducts a thorough and thoughtful process and makes recommendations to put into place guidelines, restrictions, and regulations, which I'm hearing tonight a lot of discussion about concerns of this technology because those don't exist. This is an opportunity for us to be a leader in the country and put those regulations in place. We would put in the discussion, we're looking to put in required notification to the Select Board if this technology is used during this period of exception, and to also put in a moratorium for the police department to not purchase, deploy, or obtain through grant this technology while this process is in place. I ask you to vote no action on the warrant article, and you will be seeing most likely a recommendation from our committee, as well as possibly an amendment to this article at town meeting. Thank you.
Thank you very much. Hello.
Igor Moravia, I'm a member of the Surveillance Committee as well. And a couple points. One is that I do think that it's incredibly disrespectful.
Oh, somebody leaned against the wall. Yes?
So I do think that it's incredibly disrespectful of the committee.
Wait, let's get the lights back on. Oh, technology. Even
Is that the button? Are there other buttons?
Technology not working.
The people at home surveilling us cannot surveil us.
Is there another one?
That's so odd.
That's very...
What about, David Martin, if you touch the ones behind you, does that work?
Oh, yeah, that could, maybe that. No?
No?
What about that one?
No, that's for the screening.
Oh.
Ah?
Oh, almost.
Don't touch anything.
How did?
Yes.
What did you do?
All right, so a couple of points. So one is I do think that it undermines the process that we have in place, and for folks like me who are on the committee and taking our time to do this with obviously no compensation, it kind of further in our face that, hey, your time is really of little value to this town. So I do think that it sets the wrong precedence for members like myself and the idea of these committees going forward. Secondly, to what Kay brought up, I actually Googled the Denver case, and Steve Tully, so he was actually picked up on video in the bank that he robbed. He was identified by video, not the facial surveillance, by his ex-wife, who pointed the finger at him. He was falsely arrested. And then subsequently, for a second robbery is where the FBI picked him up on the video of facial recognition technology. And he does all of the stories that I was able to pull up that do point to the fact that he is suing the city of Denver and the police department for $40 million. So I suspect that there is some bias in the spin of the story. So I think that there is a bias because he's got a $40 million vested interest in positioning this as being either a technology issue or something else. So the point is that when you bring up the fact that this is a case of facial surveillance technology being improperly used by the police department to arrest someone, no, it's simple video surveillance where he was picked up by his ex-wife. It had nothing to do with facial recognition.
Thank you. Thank you for your comments. Next.
Hi, my name is Alex Matthews, and I'm the chairman of Digital Fourth, which is a volunteer-run organization that deals with surveillance and privacy issues in the Greater Boston area. And I obviously should not be passing judgment on any of the process issues that have been brought up tonight, but on the basis of the knowledge that we have developed of facial recognition systems, I do have a few observations to make. Facial recognition...
It's a little too close. Yes.
Sorry.
Okay. Thank you.
Facial recognition systems produce a large number of garbage false positives in a way that is not necessarily helpful to law enforcement. Mass surveillance systems have this common problem. Once you decrease the friction in these systems enough that people are looking at millions of records or millions of images and having them being passed in an automated way, then what law enforcement have to deal with is a large number of potential leads, and sometimes far too many leads for them to deal with. As these systems get larger, as they pass from the thousands of people in Brookline to the hundreds of millions of people that there are nationwide, and as these systems get shared back down through the Fusion Center to our local police departments, then police are faced with a very difficult problem of large numbers of very, 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 very similar images. In a sense, it's the same as you might find with voter files. Within Brookline, it's easy to find the 3 or 4 sort of Jose Gonzalez's or John Smiths. Nationally speaking, you could have tens of thousands or hundreds of thousands of them. And so we need to be conscious that these systems are rapidly growing, and with that rapid growth comes a greater and greater problem of false positives. Even if, as your chief suggests, the system gets perfected over time, the simple fact is that the legal systems that we have are not designed for a world of rigid and universal digital enforcement. People have code violations. Some people, unfortunately, owe back child support. People have traffic violations. People have court fines and fees. If you take those older systems and you put them into a digital system of enforcement, then the result, and facial recognition systems are a part of this, is that people will get pulled in again and again and again. They may be immigrants. They may be people of color for whom these systems are not as accurate as they perhaps should be. But these kinds of systems systematically immiserate the lives of millions, and in the case of facial recognition, all the many more people that the system deems looks like the people who have those problems. The police do not have a right to your face, or to my face, or to anyone's face, except under the circumstances enumerated by the Constitution. We're a Fourth Amendment organization. We deal with Fourth Amendment issues all the time. And the Fourth Amendment problem here is that before the police subject you to analysis on an individual basis, they must have individual probable cause that it is you that has been involved in an actual crime. A chance resemblance is not probable cause, and as the father of identical twins, I'm very conscious of this as a problem. Thank you.
Thank you very much for your comment.
Hi.
Thanks for your patience as well.
Of course, I'm happy to wait. Hi, my name is Marissa. I'm a newer resident of Brookline. I live in Precinct 9 now. I'm 22, so I think I'm actually the youngest resident here. But I'm a recent Wellesley College graduate. I majored in economics and peace and justice studies. So this is right up my alley. And before that, I'm excited to be in a community where I have the opportunity to voice where I think that the direction should go. I'm a military brat. My mom is a 20-year vet of the Navy, and so I moved around with her up until I was born and until I settled at Wellesley. So I'm really happy to be here today. And I also want to thank the petitioner for bringing this up. One of the things that I've heard tonight is that people are frustrated that this has been brought forth without, I guess, committee approval. But I feel that as someone who has lived in the Boston area for the last 4 years and has now newly settled in the area, the PMV scandal that's going on is, I think, an indication that this couldn't be more timely, and that we really do need people to stand up and be forthright in their convictions despite who might want the status quo to continue for the time being. But with that, one of the things that, when my mom brought me up here to help me move into the house I live in, she and I were both struck by the community that exists in Brookline. And one of the things that I know that I've studied in school is that policing works best when it is involved with the community. And that if there is mistrust of the police within the community, then it makes it harder for the police to do their jobs. And I firmly believe that using this facial recognition technology will continue to pit the police and the community against one another. There will be a burden of suspicion upon the community that will be difficult to throw off, especially when there is the perception that technology is irrefutable. And I think that one of the technologies I've studied more recently that is seen as using technology in order to lift the burden off of marginalized communities that are most affected by these technologies is in California. They've recently moved from a individual basis of getting bail to using algorithms also that use proprietary technology to kind of rate people on a scale of like who is deserving of bail bonds. And what they have found that because of the disproportionate policing of marginalized communities, that those people are more highly rated as being a flight risk. And because of that, they're more likely to stay in jail awaiting trial, while people who have not been as heavily policed are allowed to go free. And given that Brookline is a high residential area, I fear that as more people of marginalized communities move into these areas, they will be more policed by virtue of the places that they frequent and by the places that they live, because there are more, by virtue of there being more cameras there. And so it is unfair, it's racist, it's sexist to have this technology, because it really does, it depends on who you are to see if you will be policed by this. And it puts the burden of proof onto marginalized communities that probably can't afford the defense attorney rates that the woman who came up here before probably charges. If you're working with a public DA to throw off a facial recognition charge who is overburdened and working on 12 other cases on no sleep and probably is earning my nonprofit salary in order to help these people, there's no way that we're going to be able to provide the burden of proof, give the proper sense of justice, and give people an opportunity to live their lives. And on a more personal note, I've never really had any interaction with law enforcement. I've never even gotten a speeding or a parking ticket. I still don't want people looking at my face and knowing who I am. One of the police chief's comments was that, iPhones use facial recognition and things like that. That's fine. I bought my iPhone. I actually didn't turn on the facial recognition option because I didn't want it, although I know I'm still being tracked by virtue of having a Facebook account. But I also opted into those things. I don't want to have to authenticate my identity by just stepping outside of my house and walking down the street. I know I have a pretty long walk, so there are probably a lot of cameras along the way.
We only have 11 in this town.
Oh.
Government, yes. We have 11.
And that's fair. We live in a society where cameras are helpful to tracking crime as it happens. But I shouldn't have to authenticate my identity to exist outside of my house. And I shouldn't have to worry about the high rate of coincidental charges that happen just by virtue of someone being at the same place that a crime has been committed. There are a lot of studies that show that these sort of algorithmic technologies and tracking of cell phones and tracking of facial recognition actually just serves to create plotting points, almost like how GPSs work, where you have three intertwining circles that pinpoint a probable spot. It's kind of the same as being a person out in the world who happens to exist where another crime has happened. It's not fair or constitutional in the process of governing and of existing as an individual. And it isn't necessarily impacting the quality of policing that exists right now. I feel the way that some of the officers who I really appreciate the work that you do in keeping our community safe, this isn't preventing you from being police officers. This is just protecting people's identities and protecting their autonomy as they exist. Thank you for listening to my probably longer comments than I thought that they were.
Thank you, and welcome to Brookline.
Hello, I'm Michael Dowd with live in Precinct 12, also the spouse of the petitioner, but I'm here actually because my day job is as a privacy lawyer, and so I spend my time reading through privacy statutes, and words matter in those things. So lots to say. The prior speaker was right on point. You can't opt out of these things. There are lots of reasons we should have this prohibition, but I'll stick to two different distinction pieces. One is that we talked about, how about doing a moratorium? If ban's too severe, let's do a moratorium. This is Brookline's moratorium. It maintains a status quo. We're being told it was used a few years ago. Prior chief, we don't do it now. Don't worry about it. That's fine. Let's have this in place. We'll keep the status quo for it not to be used. And if in 6 months, a year, 2 years, we have some better regulatory scheme, we can then amend this bylaw and replace it with a scheme. If you have a moratorium, the moratorium is going to expire, and expire into what? To an unknown future. So why leave it unknown? Let's control our own destiny here, have this in place, maintain the status quo, and if and when we think something should be changed, we can do that regulatory scheme in town meeting. Then as far as the sort of the legally statute piece, just want to be clear here. Nothing in this bylaw talks about data. It's only about facial surveillance technology being used, which is the software that performs the algorithms. That's what you can't possess. If it's evidence, if it's a gun, its own lying around, you can pick it up, you can use its evidence, whatever you want to do. It's not about data or thing that way. It's about the software technology that's doing it. And to drive that, so it never is ever banned in the first place, in the first half of the article. And the next part, 2A, the very first exception, it's quite clear. Nothing shall prohibit the police or any other Brookline individual for the town obtaining or possessing an electronic device such as a cell phone or computer for evidentiary purposes. So the various parade of horribles we heard earlier about someone breaks into your house with guns and does all sorts of crime, but someone's got a phone that somehow got them, you can take that phone. You can take that electronic device with you. Is there a question?
No, I just don't remember that having been discussed, but that's okay.
Okay, well, I think there were 2 or 3 things. One was someone breaks into an apartment with guns, someone has a phone with some facial recognition thing on it from Facebook, whatever it is. That's fine. You can take that phone with you. That's right in 2A. Please read that. There's an exception for that. And there's no prohibition anywhere about collecting or gathering evidence. If some other agency or individual or private citizen or business has evidence, you can collect it. It's not even covered by the ban in the first place. So what we heard, and also we heard one about, I guess, a criminal running around Arlington and Brookline, and we can only prosecute there. We can't do it here. Again, there's nothing in this ban preventing any sharing of evidence, any collecting devices that have facial recognition on them. And I think it's a misreading of this current statute. Maybe it's being looked at in the original version. But if you read Section 2A, it's quite clear, I think, that those scenarios we heard about are simply not covered by this bylaw.
Thank you very much.
Hi, my name is Erica Walshinsky. I am a Juris Doctorate candidate at Northeastern School of Law, and I live on Center Street in Brookline. I have a couple different responses to points that were brought up. One is that the idea that it denies justice when we use flawed technology. It doesn't only affect the person that would be accused of a crime, but if they are misidentified, a wrongful conviction also means that the victim has been denied justice because the perpetrator, who was not identified, was not brought to justice as a result. And there's also important to think of the entire effect that this would have on vulnerable populations. I know that children and seniors, people with disabilities was brought up, but I would implore you to think about the devastating consequences that would happen if a person in that group was misidentified when they do not have the capacity to advocate for their own identity. I can't even imagine being, for example, a parent, having your child be missing, and this technology identifies a child, the child is brought to you, and it is not your child. Or to have any other vulnerable person be brought to somewhere that is not where they actually are from, but they cannot express that information. There's really big consequences that could happen in that respect as well. And in terms of going forward, Massachusetts is notoriously opaque in terms of public records and information, and once this technology is allowed, it will be extremely difficult, if not impossible, for, at the very least, average members of the public to get information about how this is being used later on. I don't know how to submit a FOIA request or a public records request, but even when you do, it still doesn't actually work most of the time. So if any of this gets put into place, like, this is the only opportunity that we really have to prevent that from happening. I also wanted to take issue with the fact that the chief said that this would have a drastic impact on public safety, but we're not using this technology yet. I'm a little confused about how technology that we're not using, not being able to use it, would have an impact on public safety. That just doesn't seem to make sense. And so just in conclusion, I think there's really significant privacy concerns. This could make things more difficult rather than better for some vulnerable and marginalized populations. And I think that it's something that, as previous commenters had said, that the ban is essentially Brookline's moratorium. We can always revisit this later, but if we don't put this ban in now, revisiting it later will be almost impossible.
Thank you very much.
Linda Olson-Pelkey, a town meeting member in Precinct 2. I'm very impressed with all the expertise in the room. I'm not an expert in this field, but I am in favor of anonymity in public and public privacy, and I feel very strongly about that. I started being a protester, a resistor, many, many decades ago, and I was aware that I was being videotaped by the FBI and everything else, and I don't want, especially in this time that we're living in with who's in the White House and what he believes he can get away with, I do not want to see mass surveillance in Brookline. And I think it's important for us to say no at this point. I can't speak to these process issues very much either, except to say that the reason that we voted in town meeting to refer Scott's original warrant articles is because they needed more work, but that it was clear that members of this community are deeply concerned about these types of technologies and their use in our town. And I just want to also say that I agree that this is our ban, and that if it does get revisited at a later date when things are improved, maybe, but the failure rates are pretty shocking. I can't really understand why anyone would want to adopt this technology at this time, given its flaws. I guess that's really all I have to say, except that with the cameras, you'll recall, the town meeting voted against them, and we got them anyway. And then we were told that that committee, the oversight committee, which I did visit several meetings and was pretty shocked to find out that it was mostly police and prosecutors on that committee. And I am not comforted by this idea that we're just going to somehow figure out how to regulate this to such an extent that we're all going to feel comfortable. I really don't believe that. So I would like to join, and it's not about being first, second, or third. It's about protecting the citizens of Brookline. And I would like to join the few other futuristic thinking and civil rights, defending communities and support the stand. So I'm very much in favor of it. Thank you.
Thank you very much. Yes.
Hi, my name is Maria Brinker. I am a resident of Brookline, and I'm also a scholar that studies action and autonomy and privacy and surveillance. And I'm going to try to say some of the things that I think haven't been brought up so much. Like I wanted, though, to echo a few of the things said before, that some of these scenarios that the police chief brings out, it was a deafening silence around all the issues on the other side, all the injustices and all the loss of security, right? So a lot of times privacy is pitted against security, right? But that is false, because it is about whose security, right? So it's like privacy is really a tool that people use for their individual security, right? So it's not privacy against security, right? Like security is an important part of why animals seek privacy, right? It's the free. It really is. Like security is the outcome, right? Privacy is the tool to get freedom and security, right? So it's really about the power of whom, right? And our civil liberties have been put in place to give the people individual power, right? And facial recognition software is an incredible infringement on the individual liberties of the person, right? And the reason why a ban or a moratorium or some kind of stoppage is really important. This is what, so philosophers back to John Stuart Mill that wrote on liberty, right, will say the government and the people, the system in power will keep infringing on the rights and the liberty of the individual. Right? The only way you can stop this is by putting down some firm barrier. Right? This is precisely one of these examples. You put down a firm barrier that can then be negotiated. If you put down no barrier, there will be no barrier. Right? Because individual people will not be able, if you think of it from the other side, right? The police officer, it can be, bring individual cases and say, oh, we need rights to do this thing. But how is an individual, without some kind of barrier, going to protect their civil liberties, right? This is impossible. The only way you can protect civil liberties is by having them put into some kind of regulation, right? That then can be adjusted. I don't know if I'm all out of time, but I wanted to say a little bit more about how freedom and action works. So I think that people don't. So one of the problems that privacy advocates often have is that people don't understand how our action works and how we actually use it, right? So it becomes this sort of ephemeral, quaint, like, oh, you're shy, or, like why is privacy a value at all? And I think that this is because you don't see these interactions of privacy and freedom and security, like that they are not opposing values. So in terms of facial recognition in particular, how does it take away our freedom of individual action and responsible action, right? So if we think of how could this software be used, there's basically two ways that the police in Brookline could or will or right, use it, either through Brookline's own surveillance systems, which was discussed in terms of the city cameras, whether you put surveillance or sort of machine learning algorithms on those cameras to do facial recognition, or you can do third parties. Right? We've already heard the third party is probably the way that it's going to go first, right? But that is completely proprietary and undermines due process for the individual. So third party is hugely problematic because due process is undermined, and like we've heard from speakers before, it shifts the burden of proof, right? If Brookline does it as a city themselves, we develop our own ethical facial recognition software. We basically have these two alternatives, right? Third parties, or you do it yourself. Right? Doing it yourself will obviously put everybody under state surveillance, right? Because then you're walking around with an ID in public, and public space is no longer. And what that does is that it collapses the present of the space. Right, so now when you go online, you are being tracked with cookies and IP addresses and etc. You have all these identifiers, and you can try to circumvent that by different tools. But in public, as Kate Crawford also said, you can't really replace your face. Of course, perhaps if you have ill intent, you would replace your face. You would put on mask. You would try to hack the system. You would, right? But people that precisely don't have ill intent or are just going to protest, right, will be precisely the people vulnerable. Because now, normally when you make your actions in space, and this relates a little bit back to Kate Crawford's point about the difference between DNA testing or fingerprinting and facial recognition, is that the person that gains this evidence from you has to be present in the same physical space, right? And here they don't, right? What does that distance mean, right? That means that now when I go down the street, what context am I planning my action against now, right? Am I planning it against this where I meet a neighbor and say hi, right? Or am I planning it against all future uses, right, that this interaction could have? That's actually not possible to act rationally in that collapsed context. So one of the reasons why facial recognition is one of the most dangerous among many very dangerous new technologies is that it is the one that collapses all the contexts, right? Because we've heard about all these misidentifications, which are true and horrible, and I imagined all the cases of all the suspects that in that Snapchat example, all the kids that are pulled in as something, what it does to their lives to go through that process. I was thinking about all those cases. But what about the cases where it goes right? And where your contexts are collapsed. So every present moment you have to act against all possible futures of use of this present action. That undermines your ability to be authentic, right? And it also undermines your ability to be responsible, and which is something that the police should want us to be, right? And we are responsible typically for the consequences that we can see, not all kinds of unintended consequences that ensue. So anyway, I just want to say I'm a big supporter of the proposal. Thank you.
Thank you very much. Scott.
Hello, my name is Scott Nanny, and I'm a town meeting member from Precinct 10 and the sole petitioner of the Community Controlled Surveillance article in May 2018, an article of devastating consequences which resulted in the creation of the Surveillance Technology and Military Type Equipment Oversight or Subcommittee. So I will try to keep all my friends here today, because this I'd like to just start by just briefly correcting the record, it wasn't the decision to create that the surveillance technology and military equipment subcommittee, which is, I think, the committee with the longest name in and was truly a pain to fill out the application form, was not a unanimous vote. 35% of town meeting voted to refer this to the existing committee instead, the Committee on Diversity, Inclusion, and Community Relations, which also has police membership. But at the time at town meeting, it was argued would be a more balanced venue for weighing civil liberties implications of surveillance technologies. I would like to thank Chair Green, who accepted a referral. It seems to me at the last minute, in my recollection, to rescue this article and get this surveillance committee set up to begin with. So I don't wish to appear ungrateful, but I did wish to sort of say there was a difference of opinion at town meeting. And that was May of 2018. We're now in October of 2019. So easy to cry process, but I think it's fair that you shouldn't complain if some people get impatient after 17 months of process. It was certainly not a rush. And I was at the State House yesterday, and I heard Mayor Joe Curtatone of Somerville and Somerville City Councilor Ben Ewan-Campen testify about their city's adoption of their ban on facial recognition, which they did back in June, faster than we are getting around to ours. And they certainly didn't complain about any rush or deliberate plan on a rush either. I do regret in retrospect that my original community control of surveillance articles were perhaps overly lengthy. It was only my second set of warrant articles that I'd ever brought, and as the saying goes, I was too busy to make them shorter. I do think that Amy has, in fact, done a really good job at making her articles shorter rather than perhaps an overbroad look, which I had ambitiously entertained in 2018. She's sort of concentrated on one specific issue, and in fact, a one-page warrant article has grown longer only because she has been interacting with many different groups to try to address concerns and add exceptions where people can convince her they're necessary. I am a member of the committee that was formed after the referral of my articles. And in good faith, Susan, Casey, and I met this morning and have been working together. I've been trying to sort of find some common ground to bridge some of the differences of opinion that were raised on that committee. Looking with the rose-tinted glasses, I can say that among the sort of three of us, at least, there is agreement that banning this technology entirely for town and school use is uncontroversial. And in fact, banning the acquisition and deployment of this technology by our police department is also uncontroversial. The only difference of opinion between us seems to be on the use by the police department. And that's a sort of much narrower scope of disagreement. So I'll certainly continue to work with them to try to address their concerns. There's a number of ways that the Permits Committee can go on that. But I do feel personally that this issue has been discussed and is ready for you to vote on. Thank you.
Thank you very much. Is there anyone else who would like to comment? Yes.
Paul Campbell. I'm a lieutenant with the Brookline Police Department. I'm also the police liaison to the Surveillance Committee. And I just want to speak briefly. I've been listening to the comments from both sides of the argument, and I really think that there are some good points to be made on both sides. And I think that's part of the reason that this process has been frustrating for a lot of us on the Surveillance Committee. We don't feel like we were consulted, and I just can't imagine a committee more in line with a warrant article like this than the surveillance committee. My personal feeling, I'm not so sure that technology in and of itself is good or evil. I think that there may be some uses of the technology that are concerning. I think we've heard some of them today. I can tell you from speaking with the other police officers who you've heard from tonight, we agree with some of the things that people have said. No one is saying that this technology should not be looked at and that this technology should not be regulated. But I think it's wrong to say that there is no possible use for this technology, that there is no possible situation where we as police officers would want to use this technology, or you as members of the community would want us to use the technology. Someone up here gave the example of an Alzheimer's patient, and I just can't imagine a situation where we had an Alzheimer's patient or someone who, someone suffering from dementia, and we could help that person. And we said, well, we're not going to help this person because we have a regulation that says we can't. Or, I mean, obviously we're going to help the person, but that help is going to be delayed. Missing and exploited children, same thing. It's hard for me to hear some of the claims of we don't want to use this technology in certain circumstances. I just think that there are situations where we probably could all agree maybe there is a use for this technology. This warrant article doesn't allow that, and it has circumvented the surveillance committee and really I think what our charge is. You know, I just want to comment on someone raised a Fourth Amendment issue, you know, that this can be used in violation of the Fourth Amendment. Well, that's a constitutional claim. And if there is a constitutional issue, then there's already a remedy in place for that. Someone violates your Fourth Amendment right, very simply, you raise that issue of court, and that evidence is excluded. I don't know that we need a warrant article here to address the Fourth Amendment. I just don't think that that's a match. Anyway, I won't go into, there have been so many examples and positions already laid out. I won't go any further, but to me, it just seems like this is so overbroad. There was a real opportunity for discussion and to put into place meaningful restrictions that we can all agree on, and that just hasn't happened here. And to me, this just isn't ready.
Thank you very much. Before I close the public hearing, I'd like to give the petitioner an opportunity to respond, or maybe not. Any, you have talked a lot, but if there are one or two final comments that you'd like to present.
You know, just very basically, I am confident in the warrant article and the language, and I'm, you know, if there are other little carve-outs, I'm more than happy to work around that. I think this is ready for town meeting that notwithstanding, for town meeting to vote on. I think it's town meeting's right, the public's right to weigh in on this very important issue, which I won't go, the civil liberties concerns, even if the technology were perfect, and we've heard many reasons that it will never be perfect and all the other problems with that. You've heard lots of that tonight. And I really appreciate all the support as well. I think it's important to do, it is absolutely never my intention to, well, I think there's a future for changes as well, right? We are open, we are a dynamic community, we are in a well-informed community, we are a participatory community, and that can come. You don't wait for the perfect is the enemy of the good, or whatever. And I wouldn't even use that here because I think this is better than good, and I think it's urgently needed. I think there's a real need. Inaction is when everything goes wrong when people don't act. It's usually not the things that you do that are a problem, it's the things that you don't do when you don't act. And that's when we lose, our identity, our liberties, and who we are. These are our liberties. They're in the Constitution, but they don't just sit there working themselves. Laws don't write themselves. We need to write them, we need to pass them, and we need to spread the word. So I hope you'll support the article. I'm, certainly open to other comments that you may have, and thank you.
Thank you very much, Amy. So I'm going to close the public hearing now and discuss some of the issues that we heard. One thing that struck me is the fear factor involved in this. It seems that there's a fear on the part of the community being watched, sort of having no privacy in public anymore. And there's also a fear factor on the part of law enforcement that feels that this technology, if it's not available, that there's the fear that they won't be able to effectively do the work that they need to do. So I see, I think fear is never a good reason to, I don't think legislating from a place of fear is necessarily a really positive thing to do. I think that legislating from other realms is much healthier for a community. There's a tendency to make mistakes if it's strictly from a point of fear. So that's one comment. Another one is I know that so far to date only cities have passed these sorts of laws of bans, and I don't know of a test case of a town that has done this. And in Massachusetts, towns and cities operate under different, they are allowed different, they regulate differently, for one thing. And I am interested, Amy, in learning more about, from the AG, from the municipal law unit, the view of your warrant article. So I hope that you do hear back. I actually made that call today as well and did not get a response. And I know that town council, that's something it seems unclear to me how the AG's office would actually respond should this pass at town meeting. So I feel I need a little bit more clarity on that. Yep.
The answer is in the memo that I provided today, which cited to the legal standard that the Attorney General uses to review town bylaws, which is in consistency with state law. Is a bylaw inconsistent with state law? So that's a legal standard. I mean, here it seems that, one thing that jumped out at me listening tonight is, I don't know that this is an inconsistency of state law, but there's perhaps a false dichotomy being drawn between now or never and always. And if you can set a moratorium and you can have it be by policy and you can extend a moratorium, it's not now or never. But I don't know that that's something that the AG's office would consider.
Right. I note that Senator Cream's legislation, which is a moratorium, has no end date listed on it, which struck me as unusual for moratoriums. The ones that we've passed in Brookline, for instance, usually said a year or 18 months or two.
Well, I wonder if the moratorium is just she has the clause which says once
there are
there's
regulations,
a statutory framework, then the moratorium ends. So it seems like there's an action that has to be accomplished for that moratorium to end, which to me seems like a reasonable option. I don't know how you feel about that. I do feel that the biggest concern that I've heard in the audience the whole time is the use of facial recognition software for real-time application. And real-time, I've done a ton of reading on this since. Real-time application is using it to scan faces in crowds, on streets, all those ways that does not, pardon me?
And then sharing that information.
Right. But having cameras with facial recognition technology and using it to scan, and that is, I know, one of the that is one of the biggest concerns. That's where the First Amendment and the Fourth Amendment are most likely to kick in, especially the First Amendment. And I know Amy wants to respond to that, but yeah.
You can use camera footage from any time. If you have the technology, you can go back to old footage and do it and see who was there.
Right,
So,
right.
It's real time is sort of it's a false way to describe it.
Right, but using cameras in public spaces instead of, for example, taking a photo and then using the facial recognition software to go through other photos to try to pick up the individual there, which is, I think, an option that the Georgetown Privacy Project, they allow the one but not the other, because the other is the one that seems to have the First and Fourth Amendment issues. So, and I don't know whether you see a place for any kind of regulation, or whether you believe that there's no use for facial recognition software in any circumstances, and so you just want an across-the-board ban. And
That's a bigger question or a longer conversation. I mean, I don't like it, but the ban is for town meeting to vote on, and then the community to have a discussion, right? I'll weigh in on that very strongly, but that is a community discussion. The ban is, let's not get into it, let's not step in it until we know what
Right.
we're looking at. So we have
Right.
that conversation.
Well, the other option could be, let's have a moratorium until we have a statutory framework in place, and if we don't, and let's see if we can come up with something like that.
Pass the ban, let's do that.
Yeah.
Yeah, I have some specific suggestions that would make me more comfortable. Okay. I agree with Associate Town Council about adding a knowing standard. And I was wondering, would you be willing in 1A to add the word knowingly before the rest of it?
Here's no, and here's why. Because I took out face surveillance system or information derived from a face surveillance system. That was my compromise. They'll know if they're using a face surveillance system to identify somebody.
Not necessarily. If they're using information that is from a face surveillance system.
Crossed out, that's okay.
Well, so I guess the question is what you mean by use then.
Use it to identify someone.
Okay, so just having the data, using the data is not use.
Correct. I
All
don't
right.
like it. I blew a hole in the Warrant article for it.
Okay.
Compromise, which I think is a tremendous compromise, actually.
Okay,
And
moving,
so, yeah.
moving on, under section 2, I was pleased to see those additions. I think they're too finite. I think there are other ones that should be there. For example, I would want an E, use of face surveillance is permitted in medical emergencies. How do you feel about that?
I feel like it's personally, if we're negotiating, I feel like it's unnecessary, because a person in a medical emergency is going to zip to the hospital somewhere. They're not going to.
Someone's having an overdose.
I don't think you need to know who they are to treat them.
I have an issue with that because if you misidentify the person, they'll be given the wrong medication. If they're not in a position to identify themselves and it turns out they're allergic to the medication because they thought they were someone else.
Okay.
That could be a huge.
Okay. All right. No,
I think this is the issue that there's always.
And then I would prefer that there be just a general thing, or any other uses as voted by the select board, in case something comes up, because I do think waiting until town meeting, if there's a specific thing that has become problematic, waiting 6 months for town meeting to act may be too long a time, and we might want something to be handled in a more expedient way.
I wouldn't consider that a friendly amendment. I would not subscribe to that, because we've lived our entire lives without this technology. And I think we could continue to live our entire lives quite happily and safely well without it. And so I would not include that in here. There's nothing that compels me to include that person. I think town meeting should be able to vote on it without that, because again, it gets into this, then it becomes sort of a policy thing that we have this ban we really feel good about, but there's, depending on who's the select board, depending on, and people don't always, for a ban, people can show up and vote on it. If they're individual circumstances, that discretion and the balance point, counterpoint, you get and you've got tonight, isn't there. It's not there. And so, so that's why.
So, I mean, to be honest, I think the place for that sort of discussion would have been at the surveillance committee level, because they're essentially the experts, or should be the experts, on this type of technology. And the more I've read about this, the more I'm aware of how complex an issue it is, and how there are possibilities of many types of unintended consequences. And
Well, I know here, I'm still confused about C and the scenario that I gave about the rapist in the building and the Arlington people who are also looking for someone, and our giving a photograph to Arlington to use in their, because they have facial recognition software that they might use. To me, it seems like that would not, I've heard possibly from, I'm not sure, from some, yes, that I think he might have misunderstood what I was saying. I wasn't concerned about whether they could take the cell phone. So I think those are things that are still, that's not clear that that could be done. And I think there's a variety of areas like that. And you were very supportive of Cindy Cream's legislation, and I don't know why we wouldn't be pursuing that, which would force us, there's some concern about going back to the committee, because maybe the committee won't do it'll take too long, who knows how long it'll take for them to do something. If we required by a date certain that a statutory framework be in place, I'm not sure why we aren't considering that and balancing the various needs and interests and uses, addressing the risks, addressing all those concerns about this being a mass surveillance state and just not allowing that at all, but also enabling the police to have tools to do the things that they might be doing anyways. The pictures from the cameras are there, and the issue is, how are they going to be used? Is there a possible system that could be done with the software that could help them with their work when they don't have endless human resources? And I also think it's kind of a bogeyman to say that people are arrested based on facial recognition software. People aren't arrested. That is the way that an investigation gets initiated, when there's a facial recognition software system, and I think we should require that they be ones that have certain levels of accuracy, and if they don't, then we shouldn't use them. But if... No, there are objective, there's NIST, which is the National Institute of Standardization and Technology, and they do testing of different systems. There's university academic testing, and they run, people, I'm not talking about that, but if there was going to be software used, we could include in our statutory framework a requirement that it meets certain levels of accuracy, lack of bias. But assuming that exists, oh my, where was I going? It's a tool that is used, but it's used for investigative purposes. What happens is the software, which does its programming to figure out the facial structures, then goes through the other pictures that it's been given to try to find matches, and it can find anywhere from 2 to 50 matches. That is just the beginning of, that is providing a clue to the police to then further try to pursue those leads. It is no one, I mean, if someone does arrest someone based on an ID with facial recognition software, that is gross misconduct. And I mean, I'd be shocked if that, I mean, I guess I can believe anything, and I think it's possible that that could happen, but it certainly would not be the norm in a properly functioning police force to do that. It's just part of it's an investigative tool. And I'm concerned about us not having those tools. I would like to see that we have that framework that allows us to do it with the proper guidance.
We don't have those tools right now. So we're not trying to take away something that they're using. They don't have them right now.
Well, no, they're not going to be able to do, they're not going to be able to work with Arlington that might have the tool. No, if they know that that's the use that Arlington wants to use it for, are you saying that's okay? No, that's not okay. Exactly.
But if Arlington takes the lead and does the investigation and arresting on their suspect, on their crime in their town, that doesn't mean that, Brookline said, oh, you go ahead and do it. They're working on their own.
No, we can't give them the photo.
Yes, we can.
No, we can't. Not if we know that they're going to apply the facial recognition software, and that Amy's just agreed. So this is another reason. I'm not parsing. This is a very concrete, possible scenario.
Well, but the issue is, if these two things happen, and we've got a picture, and they just go assume that they're similar, and they go get that person, whatever the software does, right, with it. And so that's kind of bizarre. But to say we have a picture, this is our suspect, they can share that. They can't say, this is our suspect, go tell us who, use the software for us and tell us who he is. This does, it is a ban, Elisa, because there are problems, because there are real civil liberty concerns, it is a ban.
Right.
It doesn't let us use it, and there's no question.
Right, and I'm responding to that and saying I feel that there are uses that could be useful, and I would like to see us. Sure.
Yes, I think that's better.
So a couple of things. One, the distinction between the moratorium at the state level and the ban at the municipal level.
Right.
It's not clear to me that a municipality can regulate this technology sufficiently the way that it needs to be. One way the state might regulate it would be to say, no police department, no entity in the state of Massachusetts is permitted to possess a facial surveillance system, period. The only exception is the RMV has a database subject to some sort of super warrant. Police departments or other investigative agencies that have images of people in serious crimes like murder, rape, kidnapping, etc., or in cases like, somebody's an Alzheimer's patient and forgets his name, can get this kind of super warrant and serve it on the RMV. Brookline doesn't have the capacity to create that kind of a regulatory scheme. So really what you're looking at is kind of a binary on or off switch.
Wait, why couldn't we regulate that?
Because you can't tell the RMV what to do.
Oh, the RMV, right,
Yeah,
of
yeah,
course.
and they
Right,
actually have the
right.
database. I mean, that's the other thing, right, is that the town of Brookline does not possess a data system that tells it who every visitor to Brookline is or what their face is, right? So they rely on entities like the RMV and the state police through their mugshot database, which has a whole slew of racial justice problems, to perform these searches. So anyway, suffice it to say, the reason why the ban is appropriate at the municipal level is because they're really, if the town council has concerns about the town's ability to dictate what town employees may and may not do, I'm imagining that they would have significant concerns with their ability to tell the RMV how to use the RMV system or, how the state government can function. So just set that aside for the moment. My other point of information is that we are also very concerned about the use of these technologies on things like body cameras, and moving into the future, law enforcement officials are going to be wearing Google Glass type goggles that have artificial intelligence software built into them. walking down the street, every face that they walk past, unless we pass laws like this, will be scanned, and maybe instead of seeing actual people, police officers will see shaded colors, right? Green, red, yellow, indicating a threat level, right? This person is highly threatening. This person has a long arrest record. This person is wanted for murder and armed and dangerous. You see where I'm going, right? So decisions can be and likely will be made on a split-second basis. I can only
Well, that's why we might want to decide that would not be allowed.
That's right.
That we can't use that software in those circumstances.
I just wanted to be clear that with respect to use cases, your point was no law enforcement agency would ever use a facial recognition identification as evidence. It would just be a piece.
No, not as evidence, that would be the reason to arrest someone or convict someone. There were a lot of discussions here about someone could be convicted based on a facial recognition software. Someone could be arrested, and that's not.
That happened in Florida, and the man whose case.
And he's probably suing, and it's probably going to get overturned.
He says it wasn't him. He says it's not him, and the only piece of evidence is a facial recognition search. He was convicted of a very low-level drug crime, and he appealed to the Florida Supreme Court, and his case was actually dismissed, sadly, because of a technicality. I believe it was because his lawyer didn't raise the issue down below in the lower court. So, unfortunately, he's screwed, and yes, it did happen. So, but I just want to be clear that did happen. Additionally, and the system...
there's always mistakes made, which is why defendants will go and appeal their case. That's
right, but he couldn't. So the point is
that happens.
He's screwed. And I just wanted to say, your comment was this could never happen. It absolutely did happen. And even more serious, I think the problem from our perspective is that, again, because defendants are not being given notice about the use of this technology in their cases, we actually don't know how often this is the genesis, maybe the main evidence that law enforcement has in cases, the vast majority of which do not go to trial. You're probably familiar that something like 95% of criminal cases in the Commonwealth end in plea agreements that many times end well before the discovery process begins, especially in low-level cases that churn people of color and poor people through the system. So I think it is highly likely that this technology could actually have served as the basis for prosecutions and actual convictions in Massachusetts, and the defendants don't know and the courts don't know because nobody told them. And frankly, they don't substantively have a whole lot of due process rights because they're poor. So, put aside that, the last thing I'll say is that about the body camera stuff and, the idea of law enforcement using this technology in the field on, like eyeglasses, or something like that. That is another use case that we are trying to draw a very clear line in the sand here and say that is not appropriate in the town of Brookline. It's not appropriate in the town of Somerville. We're trying to make sure it's not appropriate in the state of Massachusetts and in that entire country, actually, because increasingly decisions, as someone else said here, made by algorithms that are, proprietary, opaque, made by people, real human beings that have their own biases and make their own errors, are increasingly being used to replace human judgment. And we want to intervene now before we go down a very scary road of enabling systems to, that are not neutral and that are not perfect to be used in contexts where life and death matters are at stake. And certainly, police stops are one of those situations. The only people wearing weapons in here are the police, right? And not in Brookline, thank God, but in plenty of parts of the country, we have seen that these incidents where, Your Honor, I feared for my life. And if we have a scenario in which these technologies are informing a split-second decision that a police officer has to make about someone reaching in their drawstring, right? Because the threat score from the facial recognition said this person had a long arrest record, was wanted for murder, etc.
Right.
I just want to be clear, though, that is a future use case scenario that this bylaw
we may want to curtail.
Prevent.
Right.
I think, Patty, would you go to the mic to make your comment? Thank you.
I just want to make sure, I answer all questions. I'm not going to be able to, I'll be out of the country for next week's meeting. A few comments on the language, which I hadn't seen this formal draft, this last draft before yesterday. So as I said, the AG's office looks at inconsistency with state law. So we'll see what the AG's office says about current state law. The question arises, given the moratorium, at the possible moratorium at the state level and efforts to regulate at the state level, whether there will be some inconsistency that develops with this ban. It could be a conflict with state statute, regulation, decisional law, federal, state. And what I did with the marijuana in drafting that bylaw is I inserted language stating that in the event of a conflict with federal or state statutory, regulatory, case law, that type of thing, this is superseded by that. So the marijuana statute has that. I don't think in that case it cited federal law because it's a controlled substance under federal law.
Right.
Yes. You get the idea. And so that kind of language could be inserted to be sure that to the extent that, for example, Chief Lipson mentioned the possibility of a destruction of evidence due process claim by someone who should have been exonerated, for not retaining, it might not be a device, it might be some other form of evidence, that this has to cede to superior powers. We are a town. We write by laws. There are superior powers to us. And another point is, I'm still not clear on why knowingly should not be inserted, given the example that the petitioner actually did cite, of providing a photograph and that violating one of these sections. And I wonder why the petitioner wouldn't use language, if the intent, and there were several people who said this, if the intent was to preserve the ability by the police to use evidence, then why not use language along the lines of San Francisco's language, which Chief Lipson read. This is very specific and limited. And if the intent is to provide the ability to use evidence, then say that. And San Francisco's language maybe does that bit. So those are, and I'm pleased to invite questions because I won't be here.
One of my questions was exactly on the Berkeley language and whether you considered it and how, and if it's not in here, why.
Amy, do you want to go to the mic? Because it's not going to get picked up otherwise. Thank you.
No, I went for very simple. I went for very simple because it is a ban. It wasn't, I went for very simple in the beginning. And actually, it was simpler when I started, and then I ended up adding more for clarity in the different, because Somerville's, I think, is that their section on the ban is something like, they don't quite use obtain, possess, access, and use, but generally you can't do that, and you can't use any information derived from, and that's it, done. You can't do it, and you can't get anything from it. So theirs is much more restrictive, and I started with that in mind and kind of went from there, not the other ways, because I did want to keep it. I did want to keep it bite-sized, and I did have in mind the fact that I stood in a committee where, we have a lot to do. I think originally it was supposed to be something, a short term, to come up with some recommendations to do long-term things. It's very clear in our conversations, there's a lot to talk about, and it's not going to end anytime soon, if ever.
Have you considered a way to do it where they could use face recognition technology from, say, Arlington if they were to get a court permission to do that?
Did not go that far with it, no. Yeah.
Okay. While you're up there, I do have a question. You define face surveillance system as meaning any computer software or application that performs face surveillance. I do think it would be possible for someone to use an application without knowing that it's using face surveillance.
That's why some of the carve-outs down below sort of point to...
Right. But that's why I really think you need to say knowingly, or else you're going to have a chilling effect on the police's ability to do their jobs.
Yeah. I disagree with it. I would prefer carve-outs that say that's okay as long as you're not actually using it, because I think in addition to the blowout compromise of removing face surveillance system or information derived from a face surveillance system, coupled with that is, starts to just enable, turning the head and splitting hairs. And I wasn't quite willing to go that far. That's, yeah. Okay.
Yes, Chief Whipson.
Thank you. I'll try to be brief. Just two really important things that I just want to hit home on again. And the regulations will be made. We're not rushing in to put out face surveillance stuff, and the regulations will come, and that's fine. The evidence is crucial. The over-prescriptive nature of her carve-outs on the evidence, the Berkeley language would be much better. The carve-outs, we are collectors of things at crime scenes. Anything that exists out there in the world, we must be able to collect as evidence, or we run into problems down the road with people's right to a fair trial. It's crucial. The other thing, I think, on the Arlington thing, we're really onto something here, and it's something that's going to happen probably right away if this ban goes into effect, is we distribute flyers all the time of photos. They go to different law enforcement agencies in different states, jurisdictions, levels of law enforcement, local, state, and federal. At some point, somebody's going to run one of those flyers through a facial recognition software and contact us and say, we think that's so-and-so. Are we supposed to ignore that if...
I don't think, do you have the latest?
No, I do. It doesn't seem clear to me.
It's not clear.
No, it's not clear.
That's the problem with these carve-outs. Every time we made an example, there was some carve-out created by the petitioner. Instead of working together, we can work together to get these right, but it keeps creating them on her own, and then I got this at 11:30 last night. But further, on the Arlington example, we could have a situation where the rapist example, strikes in Brookline, strikes in Arlington. We create a photo. It goes out. We have an eyewitness, and the eyewitness identifies a suspect that we arrest for the Brookline rape. And then in Arlington, based on the photo, they do facial recognition, and they identify somebody else. And it's actually the person who did the crime. But we've arrested somebody on a false witness identification in Brookline, but we can't use the information from facial recognition because it stemmed from that source in Arlington. It's just it's bad. And those are the things that we need to iron out.
All right. Well, it seems like that it's not, if it's not clear.
It's not clear. It's been Well, I think originally, what about, I would like to see or suggest in 1C, you had said you were referring to commercial facial surveillance
But I'm not going to add
systems.
We actually at some point had commercial in there and took it out because then that creates a big loophole. I mean, I spent a lot of time on this. It wasn't arbitrary. It creates a large loophole then for anybody else, any Brookline or Brookline official who enters into a contract or other agreement.
Well, that was to address Arlington, the Arlington issue.
Yeah, no, I wouldn't add that in. And I actually had it in one of the drafts I was playing with and took it out when I realized the problem with it because it creates a problem.
So, I'd like to interject here. This was supposed to be a 2-hour hearing. We're at 3 hours right now, so I'd like to kind of wrap it up. It seems to me that there are two very different approaches here. One is, as one of the people who spoke said, is the idea of putting down a firm barrier now and then negotiating later. The other approach is to let it go through the committee that was set up in order to develop the regulations for this, let it go through that process, and then bring something to town meeting, following that process. So,
And there's a third, which is moratorium until.
And this, right, the third would be a moratorium such as Senator Green put in place at the state level.
It's not that.
I understand that this
One is making a statement that all facial recognition software should be banned regardless of how useful or not useful it is. The other is we need to look at facial recognition software. How can we ensure it's safe? Are there uses that are appropriate? Are there uses that are not appropriate? And incorporate that into a statutory framework.
So my question really is, when the state goes through its process and sets down regulations, which may actually be broader than just no, right? Then what happens? It will be broader than no, yes. So then what happens? So our bylaw then is not doesn't match the state requirement. It would be invalidated, I think, or overruled, right? But
I think then we would amend the language appropriately, and it wouldn't be, I mean, if it was in violation, conflicting with state law, and violation of state law, then it would be those parts would be unenforceable, and we would amend it so it would be. We would address that, but we just don't know what the timetable will be. We don't know what that will look like, and just waiting. I mean, it took 17 months for our committee to get started. At the state level, they're dealing with a lot. They're just beginning the hearing process. We don't know when that will be. We don't know what it will look like. We don't know how meaningful final outcome is. So stopping ourselves before we really get in the habit of using it, I think is a great idea. That's what I'm advocating for. I think it sounds like, from what you heard from other committee members, that there may be, an option to say, well, let's, whatever. I don't know what they're going to recommend. But I think a ban is certainly one option. I want to see right before town meeting, and then town meeting can decide.
I'd like to have us talk at some point.
yes. Well, this is our talk.
Right. So
I personally, I feel very conflicted about the process, whether or not we should allow it to go through. I mean, we set up as Scott said, we set up this surveillance committee.
Can I address that, actually?
And this came up, we haven't even agreed on definitions for things in that business. There's so much to do. We don't know how many cameras there are actually. I have an estimate. We don't even, there's so much, we're still collecting information. It's not going to happen by the spring.
but
Can I just add?
Yes.
That's not the way town meeting works. Town meeting doesn't go through committees. Neil Gordon has 2 articles. He did not send it to CTNOS, wait a year for them to vet it. He put it in the warrant, and then CTNOS reacts to it. That's the way town meeting works. And there are a whole bunch of things in this warrant, where they didn't go to the planning board first and let them, and so that's just the way town meeting members work. They put a warrant article in, and then everybody comes together and analyzes it and vets it and make a recommendation about it. So I do not agree at all that we are circumventing or undermining the process with the committee. This is separate from it. It's the way it's always done. We do something, and then the committee can comment on it and say, this is what we think about it. So it's, this is absolutely proper to bring forward, I think, on that point.
Thank you.
Well, I think it may or may not be proper. I mean, it may be something that the committee members might think, why aren't you letting us do this? That's what we're doing. But, surveillance. But I think we should be trying to figure out what we think is the best approach for the town. And, right, and that's what I would like to see happening. And I guess my view is I'm not willing to say that I do not think that facial recognition software under any circumstances should be banned outright. I personally think that we should have the town discuss how to make facial recognition software work for the town, allied with the morals and values of our town. And by simply banning it, as opposed to providing a moratorium until a statutory framework is provided, seems to me a more appropriate way to go. If we are, there's the other option of let's not do a moratorium, let's not do a ban, no action or refer it to
Refer it back to the
surveillance committee.
I'm something of a civil libertarian, and
Right.
I do not think, as was stated earlier, that the state has a right to track me if I'm not suspected of a crime. You know, and what this does is basically overturns, you know, I'm not going to say 200 years of tradition. I don't know when the United States really got into the part of people with civil liberties, but I will say that, you know, if you're not suspected of a crime, there's no reason to track somebody at all. And it's just, I think this is a good article to really make a statement saying, we don't want to start a new normal where everybody is expected to be tracked in every way all the time. There are chips inside everybody's cars that most people don't know about, where the police can pull it out and tell how fast you were going and all these other pieces of data, which they can do without a warrant, from what I understand. I don't know if
But what you're discussing is the real-time application of facial recognition software. There's other I know, but there's other applications. For example, you have the mugshots, you have the camera, you can match them, you can have an officer do it.
Been accused of a crime. If you're not suspected of a crime, why would the state need to have all this information on tracking your location?
Right, that could be what the police is limited to be allowed to do. That is what the Georgetown Privacy Project says to do, to not allow any kind of mass surveillance, the kind of tracking that you are referring to, and that was discussed over and over again here with the restrictions of First and Fourth Amendment rights, especially the First Amendment rights. But there are other uses that don't implicate that, and we are just saying, let's not consider any uses and just ban it outright.
Yeah, I think either we should close now
Wait,
and
what did-
either take a vote or not take
Wait,
a vote.
Susan was about to say something.
Yes, Susan.
What I was going to say was that I think that the changes that have been made to the warrant article since its inception have been improvements. And I think this is a work in progress. But I'm not certain that it's reached a final form that I feel comfortable with, because there are competing concerns. And it's not all black and white in one direction or another. And I think that for this to be successful and not simply a statement, that, you know, we as a community will live with the implications of this for at least a year or 2 years or more. And we're a public safety subcommittee. We have to be concerned about the implications that this has on the public safety of Brookline, because if we're not, what committee will be? So I think that that creates a certain greater concern on this committee, that we not overlook the need for ourselves as a community not to create additional regulations that will have unintended consequences. I think that my preference is that this be worked on some more. I think it's close to being in really good shape, but I don't think it's there yet.
Do you want to send me some suggestions, Susan?
Well, I've discussed them and you've rejected them, so there's no point, I don't think, in doing this. But I can't, right, I can't vote for this if in its current state, even though I would like to, but I can't. So, you know, that's my.
I mean, I thought we had either clarified what was here or not.
I think knowingly is an essential aspect to it, because otherwise you create a chilling effect. People might not feel comfortable doing something that could appear to be fine, but might not be. I mean, in reality, if you make an absolute violation absolute, then people will bend over backwards not to get near the line.
May I take you up on that?
Yes.
On under enforcement, on number 4, where it says, town employees shall result in consequences. If we were to change that to may, that would give town the flexibility to basically take it on a case-by-case basis.
That's not true, because you have Article 10 of bylaws with the enforcement.
So is it,
I don't invoke that here at all. There are no finding, I didn't, because I was looking at that.
But someone could be terminated. That's a financial impact on that individual.
The enforcement for our bylaws is in Article 10.
So, I mean, that's clearly, people are willing to accept less than perfect. The question is, which direction of less than perfect are we heading in? And for some people, like me, I'm concerned about how this will impact the people who we ask to enforce our public safety in Brookline. I understand no one wants to live in a Chinese authoritarian police state, but I think that there are gradations of doing this, and I would feel really much more comfortable if there was a knowing standard inserted into this. That's just my personal belief.
I feel similarly. But I also feel that I don't want to go, I also feel that Brookline should not go down a slippery slope in this. So.
This could be amended, at town meeting, it could be amended. After it passes at the next town meeting, there are a whole.
And maybe it's amended at advisory committee.
Well, I don't know if you're going to decide to vote tonight or not. But if you want to send me written comments as well, I mean, this is continued to be a work in progress. I am trying to be responsive. I am not going to give up on the general principle that I don't think government use of surveillance technology is good, period, because of all of the many reasons stated. But this is not meant to go out and catch people, be punitive in some way, or stop the collection of evidence that generally just needs to be collected, right? It's that my goal is to not, like I say, step down that path. But I'm happy to do it responsibly.
Okay.
So, can I just say,
Yeah.
because I'm not going to be here next, so Mike, you have my comments?
Yes.
Yeah, I'm not going to say anything, I'm not going to try to do that. Also, knowingly, take up the civil cause of action, change the evidentiary, card out to something more like Berkeley's language. Have the superiority of law hierarchy language along the lines of what's in the marijuana bylaw, but add federal. I think that's all.
Yeah.
What I said.
I'll probably, just so you know, I'll probably keep this in because I have the severability clause. I figure they'll just, if they
You're in
really.
the civil cause of action.
I'm in the civil cause of
On that
action,
one.
sorry. Yeah, and I feel like they'll pluck it out. I'm not just going to arbitrarily pluck it
All
out.
right, so,
I think there's a lot.
yes.
If they don't, though, that's inviting, you're running lawsuits, right?
Make a motion to
Yeah.
not, to continue.
I understand, but I want them to be taken seriously.
I'm going to make a motion that we continue this hearing next Tuesday before advisory.
We meet at 7 next Tuesday. It was, yeah.
Next Tuesday is the 20 what?
29.
29th, okay. So there are no subcommittee meetings or anything that I know of on that date. So if we were to meet at 6, or even 6:30.
Well, I'm just checking.
Or even 6:30, and just continue this, and then depending on any new language that comes around, then we could vote on it. Because if we do vote tonight and then it substantially changes, our vote is out of date and it's not with the current version, and then we have to go through it again anyway.
My sense is the language is not going to significantly change. Yes.
I don't think it will, but, I may tweak it, because again,
Okay.
I am trying to be responsive.
Yes.
I'm firm in my beliefs and what I'm going to stick with, but I do, I do want to be responsive as I can be.
Okay. All right, so I'm going to second that motion that we continue to 6 o'clock on the 29th for possible vote and certainly consideration of your next red line version, Amy.
6 or 6:30?
Do 6, because everybody here likes to talk.
Yeah, I think 6 o'clock. We'll find a room at 6 and note it. We'll get it noted on the town calendar. So I thank you all who stayed for the 3 hours and 20
Anybody's
minutes.
asleep, wake them up.
And thank you all for your comments.
Thank you for your public service. Yes, thank you.
Thank you for yours.